have business before this honorable court are admonished to draw near and give their attention as the court is now sitting. God save the United States and this honorable court.
Good morning, everyone. Our first case this morning is Appian versus Buth et al. Ms. Terhune, whenever you're ready.
May it please the court, my name is Abigail Terhune, and I represent the appellant Grant Lyon on behalf of the Appian ESOP. In August 2017, Mr. Lyon was appointed as the ESOP's independent fiduciary. He had no ties to Appian's management and started a truly independent investigation of the Appian ESOP and the valuations that had been used to set the price of its stock. He relied on his background in valuation theory and corporate finance. And by September 2017, he had identified the core valuation irregularities at issue in this lawsuit, had confirmed his conclusions with the ESOP's then trustee, Argent Trust Company, and reported to Appian's board that they should stop allowing investment in PDC stock. Mr. Lyon then complied with his ERISA statutory obligation to determine who was responsible for the inflated valuations and brought these claims. The district court found that the Second Amendment complaint stated a claim only as to Argent, the ESOP's final trustee from 2014 to 2017, relying on admissions from Argent's employee about the valuation process. But Argent was only involved at the end and is not the only one responsible for the years of overstated valuations in this case. It is also—
I wonder, for me at least, it would be helpful if you fast forward perhaps to a discussion of the statute of repose, because I'm not sure the district court was actually saying that nobody else was responsible, but there is this statute of repose that cuts off the ability to pursue certain claims.
Well, yes, he did both, actually, because he did not allow or consider the claims within the statute of limitations period against the
Right,
but
let's just, for starters, look at the pre-November, whatever it was, the 2012
Yes.
claims.
So that is under ERISA 513, and we need to invoke the fraud or concealment exception to get back past that time period.
Right.
The district court did not think the concealment could take place in the course of the underlying wrong. And he required a separate course of conduct to conceal. And we think that is inconsistent with the court's holding in Martin v. Consultants and Administrators. The fraudulent concealment can include genuine acts of concealment committed in the course of the underlying wrong.
But here's what I'm curious about there. I didn't read it quite as broadly as you are. I think the court, as I understood what the district court was saying, was looking for something beyond just the alleged acts of fraud. It didn't mean, if you think of Venn diagrams, it didn't mean that a certain amount of the behavior was overlapping, but you had to find actually concealment, some sort of, in the Supreme Court's very old phrasing from 1879, some trick or contrivance, right? And so why is that wrong? Because otherwise everything would overlap if just fraud was automatically concealed. People don't usually stand on a high place and shout out, "I'm defrauding people."
Yes, this court has drawn a distinction between fraud and fraud that is concealed.
Right.
But the concealment, the trick or contrivance, can occur in the course of those breaches of fiduciary duty here, the underlying wrong. And we think we've alleged both affirmative acts of concealment that are separate in time from the underlying breaches of fiduciary duty, as well as self-concealing acts that took place during those breaches of fiduciary duty.
But you have pled a very broad fraudulent scheme here. And the concealments that you've identified in your briefing, if you go back and look at what you have pled, really line up with places that you have pled that concealment as part of the fraudulent conduct.
Well, yes, but again, it can be part of the fraudulent conduct as long as it operates to conceal. And here we have—
But let's take a concrete example. Is just keeping your mouth shut something that operates to conceal?
No.
All right, so we need something more than omissions to disclose what's going on.
Yes.
So what do we have that's more than that? What are your best, acts and allegations of efforts to conceal?
Well, the stock prices themselves are self-concealing. They are presented as the result of a prudent process while it's not. I mean, it's important here that a lot of the allegations here are based on a failure to follow a prudent process.
But isn't that just silence? It's here it is,
No, it's an affirmative representation that this is a stock value, and that carries with it a representation that this was the result of a prudent process and a good faith process according to ERISA 318.
How is that concealment as opposed to fraud?
I mean, they did not disclose well, it's both. It's part of it. I've seen one case that described, used a vase analogy. Stealing the vase is not concealment of anything, but presenting a vase as an antique vase when it's just a replica, that's a self-concealing wrong because it's presented as something that's not, and you don't know that.
Let's take a simpler example out of this context. So let's say, I don't know, I guess I go back to this example a lot, my clerks will tell you. Let's say that I'm selling you a used car, and I say, it's worth $10,000, but I know it's not, okay? Mm-hmm. And I go, you know how I know it's worth $10,000? Because it rides beautifully, right? Mm-hmm. Is that concealment? Or is that just fraud? Right? And isn't that what we have here? Is that your allegation is that they knew that the stock price was X, but then they said it was Y, and they said it was Y because it ran really well. The company's doing really well.
No, I mean, they had an obligation to follow a prudent process and act as prudent fiduciaries in valuing the stock. And they failed to do so. And in addition to the actual stock prices, we've pled extensive communications, newsletters, emails with the employees where they're describing the valuation process. They're assuring them that they're following a proper process. But at the end of the day, they were not. They were ignoring certain key data, for example, the pension liability, and they were applying a control premium. This stuff is not evident from the stock price itself. It's not evidence in the 10Ks, which we also allege were acts of concealment.
Well, wait a minute. I believe that the 10Ks did disclose the total debt. And if somebody wanted to rummage around in the SEC's websites and pull up the 10Ks, they could have found out this. It wasn't mentioned in the kinds of communications you're talking about. But I wonder if the record really shows that they could not have discovered this pension debt, et cetera, from the 10Ks.
I don't think they could, Your Honor, because it's not the valuation process. The valuation itself was not disclosed.
But I thought the debt was disclosed on the 10Ks.
The debt was disclosed in the 10Ks, and that is our position.
So they could have put this information together in a way that perhaps Appian had not done.
But how do you put that information together if you don't know what's going into the valuation number? It's a black box to anyone other than the fiduciaries who are privy to that. They were not disclosing that information. It was confidential information. And so they were not...
But again, why isn't that just an omission? Why isn't that just being quiet?
Because they are...
Where's the trickery or contrivance in that?
I mean, employees did ask for access to these valuations, and they were denied. And I think that was an attempt to obscure their valuation process. They didn't really want anyone seeing what they were doing in these ESOP committee meetings or what was in the valuations. The valuations themselves were also, they weren't allowed to share these. The express text on the document said they could not be shared without Stout's express written consent. You need the valuation, and Mr. Lyon is the first one who had access to the valuation, who is an independent fiduciary, and could compare the balance sheet and the valuation. And so that is a trick or contrivance, especially in combination with these emails, which are very selectively explaining the valuation process or what went into the valuation, but not disclosing all of these issues. And those emails, which are extremely well pled in the complaint, many of them are copied in part or in full in the complaint, are very misleading, and they're directly a trick or contrivance to conceal.
I'm still not comfortable with the way you're dealing with the 10Ks and the other information. Wasn't Mr. Lyon simply looking at this information in a different way? I mean, obviously, when you don't have a publicly traded company, you've got to come up with some valuation of stock, and you're going to look at assets, you're going to look at liabilities, and I'm not convinced that that there was the kind of concealment you're talking about, given the publicly available information.
Well, I'd note that Fish v. Great Bank, dealt with actual knowledge, not this quite issue, but it deals with knowledge of a process. When do you have actual knowledge of a process? And these kinds of surface level information does not put you on notice of that process that was used to value the stock. I would also note that the 10K...
So are you saying that there is an I want to get back to the statute of repose, because this really does either allows you to go forward with a lot or trims this case back quite considerably.
Yes.
If you don't get it. And you are saying that they presented these numbers to the ESOP participants, I'll say, up through this chain of ownership, as though it had been done in an appropriate way, and it really wasn't done in an appropriate way. And that is enough, in your view, in and of itself, to show that there is a scheme to conceal, that there is a process to conceal. And I still haven't quite grasped how that's different from just keeping quiet and saying, this is what we did, this is the value, buy the stock.
Yes, that is our position. I believe it's different, especially here when the financial statements disclose the pension debt and disclose the interest-bearing debt. And obviously we allege that the pension debt was never deducted, and that is a problem. The interest-bearing debt is actually a harder case because there were portions of the interest-bearing debt that was not deducted. That's even harder to detect. You don't know from comparing this information. I don't know how you could back into those numbers when they're just saying, this $30 million doesn't count this year.
Wouldn't the exception get swallowed up based on your argument that any time you're alleging fraud, you'd be able to get around the statute of repose?
I don't think that's what we're saying here. It's not just fraud. It's fraud in a kind of closed environment where other people were not allowed access to it because of specific decisions to not make those valuations.
Well, that's often what fraud is, where others aren't allowed access to it.
Well, the line between fraud and, affirmative acts of concealment is not especially clear. Wolin made the point that this is that this is a very confusing area of law, and the line is not always tidy. It's always a matter of opinion. For example, is passing it off as a replica, is that just the fraud, or is that concealing it, the vase? I think those acts of concealment, they are acts of concealment committed in the course of the underlying wrong. And we have additional acts here where it's not just the underlying wrong with the stock process, the process of evaluation, but it's also the communications, the later communications to employees about the process, which those affirmatively concealed, along with the 10Ks, which they listed the pension debt and they listed the stock value, and they didn't describe anything about the valuation process.
So your position has to be that maybe somebody could look at that and think that the stock value had reflected appropriate deductions for the pension debt.
Yes.
So on that one point, and this actually goes to the claims within the statute of the ones that you can't get rid of on statute of repose grounds, is it your position that just dollar for dollar this pension debt needed to be reduced? Because the argument is made by the other side that it was contingent, it was in the future, maybe some of it would never come about, that it wasn't just a dollar for dollar deduction. I realize you wind up with a company worth less than zero if you just subtract the pension debt.
Right.
But there is some question about how to treat it.
They have put forth attorney argument on that issue. We think it needs to be deducted dollar for dollar. I think the bigger issue is that they didn't consider it at all. It's referenced in a few places in the valuations. Early on, just when they were discussing the balance sheet, they were aware of this pension debt, and yet there's no evidence that they actually took this into account in their calculations. This is very large dollar amounts. And then I'll
so
note
you would be saying then, I would guess, that even if you should have just taken 50 cents on the dollar, you've alleged enough at the 12b6 stage to get into the question, to get into the question of how much should be deducted.
Yes, and I'll also note that in mid-2016, they recognized a specific short-term need to fund an additional $19 million into the pension plan. And Stout spoke with the ESOP committee members, I believe Mr. Faree or someone on the ESOP committee, and said, oh, we're going to find these other synergies somewhere to save this money, so we don't need to take that into account. And that flies in the face of even the defendant's reasoning on why they did not need to deduct the pension debt. But I also like to note that I don't think the pension debt needs to be viewed on its own. We've alleged a lot of irregularities with the valuations, including these inflated projections, and the control premium, and the failure to deduct even interest-bearing debt, such as $30 million of revolving line of credit.
So on the control premium, it wasn't a big control premium, though, wasn't it? I mean, you've made the argument that they didn't really have control, and therefore no such premium should be there. But there's kind of partial control, wasn't there? And so this was a partial adjustment?
No, there was no control. There's a security holders agreement, which was signed after as part of the 2001 ESOP transaction. And at that point, the ESOP trustee was initially able to appoint a minority, their control, their ability to appoint or remove directors decreased over time. And after, I believe, 2005, they could not appoint any directors on their own or remove any directors on their own. And the case law has been very clear that this is important to control, this ability to control. And I also disagree that a control premium is appropriate for this kind of ESOP valuation on an ongoing basis. Control is about your ability to recognize a synergy. You buy the whole company, you get some kind of value. That's not what they were using these biannual valuations for. And that might be explained why some of the third-party offers, none of which succeeded, were slightly higher than you might expect, because they could have gotten that kind of synergy. The employees could not.
Can I clarify on your claims against Houlihan? You seem to concede, maybe implicitly, that you cannot pursue your ERISA claims against Houlihan. Do you agree with that?
We had a lot of issues to appeal in this case, and we decided that the common law arguments were stronger than the ERISA claims.
So you agree you cannot state an ERISA claim against Houlihan?
Yes.
All right.
And while we're at it, you didn't repeat the state claims in your Second Amendment complaint.
Yes.
And you've briefed the fact that since the district court had ruled definitively on them, that they're still alive.
Yes.
Is that correct?
Yes, I believe it's Bastian v. Peters. It's already a very lengthy complaint, and we knew we were going to face more motions to dismiss, and so why annoy the judge, I believe, was the reasoning of Bastian v. Peters.
But why are those state claims not just alternative enforcement mechanisms that ERISA would push aside?
So we have claims against the D's and O's for a corporate breach of fiduciary duty, and those are on behalf of the ESOP as the sole shareholder of Appian. It owned PDC,
yeah,
and then
right.
PDC owned Appian. And Halperin v. Richards is actually a related case to this. It's the Appian Liquidators Trust, the creditors committee. And there, this court looked at this kind of dual hat issue, and ERISA's created and invites this kind of inherent conflict where the D's and O's are wearing dual hats and they owe duties to the shareholder. And in Halperin, this court explained that ERISA was not intended to shield directors and officers from that exact type of fraudulent conduct, for a corporate claim. And we think that applies to the ESOP here as well, especially because the claims we've stated on behalf of, or for the common law claim, are attempted to not address ERISA issues.
Didn't we left open a question, though, in Halperin about whether ERISA would preempt a similar kind of claim if it were brought by ERISA beneficiaries, et cetera, who have a claim under ERISA?
Yes, that's correct.
I mean, that's a fairly big reservation, seems to me.
It is. But, we've stated ERISA claims that go after what we believe is the fiduciary hat behavior. And then the corporate law claims are meant to address other issues where the ESOP was damaged as a shareholder but the activity might not arise to ERISA actions.
To follow up on Judge Wood's earlier question about not repleting your state law claims against Houlihan, did you give any indication on the record that you were going to rest on them, but you weren't going to replete them?
No, that was not apparent that it was needed from the case law on that, I believe.
Okay. Some cases have suggested that should be given.
And to address the state law claims against Stout and Houlihan, these are fraud and negligent misrepresentation and breach of fiduciary duty for Houlihan claims, and they are just these are garden variety tort claims. They don't relate to the ESOP plan in any meaningful way. ERISA does not regulate their conduct. It doesn't explain how explains how the trustee is supposed to act with respect to evaluation. It does not explain how Stout is supposed to act with respect to evaluation, for example. And I don't believe the ability, whether theoretical or not, since the court has not addressed whether you can bring an ERISA 502A3 claim against someone in this situation. I don't believe the ability to bring that claim should bar this. That's an aiding and abetting claim. This is a direct claim based on direct duties owed.
You are into your rebuttal time,
Yes,
if you want to save it.
Yes.
Up to you. Thank you. Mr. Martin?
Good morning. Craig Martin. I represent the directors and officers, those defendants with regard to this case. We request that the judgment of the district court be affirmed. Just to put this case in context, Appian, just the company, the way I always think about it, is it's one of the companies that made the paper that you used to use for credit cards with the carbon on the back.
We've seen lots of cases involving Appian and Appleton in
Yes.
more environmental settings, I would say.
Yes. We don't see that paper anymore. So a little bit about
And
why we
you've
may
been
be
cleaning
here.
up the Lower Fox River for a long time.
For quite some time. Look, the core theory with regard to this case is that the directors and officers and the others engaged in a long-term fraudulent scheme to inflate the stock price from the beginning transaction throughout the entire time. The case with regard to the issue that you were just talking about a moment ago is the 29 U.S.C. 1113 issue. And I'll spend a little bit of time giving you our take with regard to that issue. The Seventh Circuit in the radiology case clearly lays out some parameters, and essentially going to the Venn diagram says that you can't really have the same exact fraud to extend the statute. So
But why isn't it, for the post-2012 claims, the ones that we're not going to worry about the statute of repose, why isn't, just to take what seems to me one of the big examples, the continuing failure to reflect this huge pension liability something that requires further development in this litigation, whatever may come of it eventually?
So I'll go to the post-2012 claims, and the district court with regard to those claims essentially holds that they fail to plead fraud with particularity under Rule 9b.
I read that, and I love Rule 9b. I like all the procedural rules, but you don't assert intent, knowledge, motive with the specificity that Rule 9b otherwise requires. There's an explicit carve-out for those things. Those can be alleged generally, and there's a great deal of detail as to the who, what, when, where, why, how, parts that you do need to spell out clearly. So I'm not sure that the district judge seemed to be kind of conflating the particularity requirements with its notion of plausibility, and those are just two different parts of the inquiry.
Yeah, so I think the district court, whether the district court conflated it or not, I think the main point with regard to the case in 9b is this. With respect to the 17 directors and officers, and I'll just take them as an example. The 17 directors and officers do not, and there's no allegations anywhere, that they are involved in the valuation. They're not involved in the valuation. They're not involved in whatever was going on with Willamette and Stout, who were doing the valuations over a long period of time. The directors and officers were not to use the Hamilton analogy, they were not in the room where it happened. And there are no allegations with regard to, here's how we came up with a valuation, and here's why it was, fraudulent, right?
But
So
didn't they have a supervisory duty, though, to, they couldn't just rubber stamp anything that Stout put in front of them.
There's certainly a supervisory duty, but in this particular case, the core allegation against the directors and officers in each and every one of them is that they participated in fraud. And the fraud needs to be pled with particularity. And with regard to the valuations, just to kind of get into that a little bit more, what would be fraudulent? What would be fraudulent is if the directors and officers, or some director or officer, had one set of books and it said we were going to make 17 widgets next year and our profits were going to be 50%, and that was the set of books that was used to trick the rest of the system, and then had another set of books that said, well, actually we're going to make 7 widgets and our margin's going to be 20%. That would be classic fraud. That's what would need to be pled here. There is no allegation of classic fraud. And when you have the debate, or I should say the discussion, Your Honor, with counsel for the appellant with regard to, well, this is a pension liability, how much should it be valued at, and so forth.
Right.
That's a legitimate discussion that would go on in evaluation, and I can imagine people doing their discounted cash flow analysis and their multiples analysis and so forth.
Well, so can I, but I don't know how you come up with 0 after that evaluation. That's what bothers me. Not whether it was dollar for dollar, but it could have had a profound impact on the imputed price of these non-publicly traded shares.
Right, and to go to the, I'm not here to second guess the valuation, right? But to go to the fraudulent allegation might be, to take that as an example, we have a pension liability. It's $1. We think that pension liability is going to be 90 cents, and it's going to hit us in 2027. And that's one set of books that we have. And then there's another set of projections that we have that we don't give anybody.
Are you saying there are no allegations that the directors and officers knew that these should be included in the valuation? And they weren't?
There's no allegation that they're certainly, look, it's just true that is known, as we point out in the 10Ks and so forth. The pension liability is known, but in terms of how it's used in the valuation, the directors and officers are not involved in the valuation, and there's no allegations of what they did in the valuation. The only allegation with regard to the directors and officers, it really is that they had overly rosy projections.
That's exactly what I wanted to ask you about next. It's not that they had an overly rosy projection for 1 year and then they righted the ship, so to speak, going forward. Year in and year out, the projections were in excess of performance, and they kept using these numbers that were becoming increasingly unreliable.
In terms of the numbers and the projections that they were using projections and they were giving them to a valuation firm, right? And there's no evidence, it's the wrong word, there's no allegation with specificity under Rule 9b that they were doing something that was fraudulent with respect to their projections and valuations. So we wake up every day and we say whether or not our business is going to make money, and we go ahead and project for the next year. And sometimes we project well, and sometimes we don't project so well.
But you always project badly on these allegations.
On these allegations, they always overproject. But it's not the only company in the world that overprojects, and that doesn't mean that they engaged in fraud. If they had a different set of projections that they were failing to give to somebody, that would be a classic allegation of fraud, which is what you don't have here.
But you don't have to have the two sets of books. I realize that's an example you can use, but if they are, if the other hypothetical set is just in their minds, the Second Amendment complaint pleads that this is something that pumps up the value of the stock, that causes the ESOP to overpay, for its shares, and it redounds to the benefit of, among others, the directors and officers. I mean, we need to put all these facts together, right?
Yes, but it's, respectfully, it's not a negligence theory, right? The core theory.
No, it's a
of the
deliberateness
complaint
theory,
is
and
a
it's certainly
deliberate
pleaded
fraud.
as deliberate, but that's the intent which you can plead generally.
Yes, with one exception under the PLSRA. But in terms
Well,
of...
we're not talking about the securities claims right now.
Yeah, but in terms of the allegations with regard to projections, there's no allegation with regard to the who, what, when, or where of fraud with regard to those allegations. There is an allegation that they made projections and that their projections were overly rosy. That is an allegation. In terms of what you would expect in a commercial setting is that a valuation firm that was dealing with, a company for many years would have their own, view on that. So, for example, and by the way, I don't know because there's nothing pled about it. So, a valuation firm in an evaluation may say, well, look, they've come in and they've said that their projection is this. I'm going to discount that by 22%, and so forth. I mean, the truth is that happens in business all the time, and that would happen in a valuation expert conversation, as well as how to account for the pension liability, the control premium, and so forth. But there's no allegation that there is fraud embedded in those valuations. And there's no
I
allegation.
think there are allegations. Your point is really more that you don't think they're sufficient. Of course, we have the disadvantage in this case of overwhelming amounts of paper. The Second Amendment complaint, if for whatever else you criticize it, it cannot be criticized for brevity. It's the opposite, and so hidden amongst those hundreds of pages are actually quite a few allegations of fraud, it seems to me, of knowing behavior, not simply negligent behavior.
Combing through the big complaint that's in my binder, under Rule 9b, they do not, if you tie it to the 17 directors and officers, they do not allege under Rule 9b that our people the who, what, why, when, how of fraud with regard to the valuations.
Can I ask you whether this group of 17, everybody agrees they just stand or fall together? There are no internal distinctions among them?
There are internal distinctions among them for purposes of the 9b argument. I don't think there's any meaningful distinction among them. At times, the complaint is more specific about one person or another, but it is never specific when it talks about fraud. And
The distinction would be timing, too. Some of them
Yes.
were only involved pre-November 2012.
Yes, I have a big chart.
I have one, too. So.
Mr. Martin, if I could ask
yes,
you
sir.
About the preemption issue. Combing through looking at the complaint, there seems to me instances where the breach of fiduciary duty that's alleged against the DNO defendants really are just run-of-the-mill corporate breach of fiduciary duty claims. So, for example, if you look at around the vicinity of paragraph 770 and following, it talks about how the directors kind of breached their fiduciary duty to the shareholder because of the way they handled the Encapsys transaction, right? And we see that in regular corporate lawsuits all the time, right? So there it seems to me that the claim is being brought up as in their capacity as shareholder, and even if the shares were held by an individual, for example, the same claims would exist. And so why isn't that an example of a portion of their fiduciary duty claims that might not be subject to ERISA preemption?
So that's the question that was left open in the last case, yes. Right? And with regard to, I don't have that particular paragraph memorized, so but in
Oh,
terms
I didn't either. I had it written down. So.
So with regard to, going back to the preemption statute, right, it relates to an ERISA plan. These are ESOP participants who are part of an ERISA plan.
Right, but if
not
the
just
claim
regular
could have been
shareholders.
brought, whether or not the owner of the shares was an ESOP participant, was an ESOP, or whether it was just, Joe Smith off the street, if the duty would have existed under state law under either scenario, what is the argument that such an independent and parallel duty should be preempted under ERISA?
Yeah, so I think, I think it gets right into the last opinion, but it's in terms of here you have ESOP participants who are stockholders. They are clearly within the ERISA statute. In the case of a regular corporation, you have shareholders who are not within the ERISA
And so
statute.
is your argument the very fact that the shareholder is a ESOP that basically automatically takes any breach of fiduciary duty claims or preempts any state breach of fiduciary duty claims?
I don't know that I would say it that cleanly, but I would say in this case it does, because the allegations arise out of what is core and fundamental to the operation of
So,
the
of course,
ESOP plan.
my next question is, what is an example, if you say it's not as clean, of a claim for breach of fiduciary duty in state law that would not be preempted by ERISA in your mind, where the shareholder was an ESOP?
Can't think of one, to be honest, because the fundamental duty is governed by the ERISA statute and the ESOP statute, and therefore it is preempted, and it is also the exclusive remedy. So I think that it is a complete distinction versus corporate shareholders in a typical public company.
So you think so get back to my question, you would agree then with the proposition that whenever an ESOP owns shares in a company, that all state breach of fiduciary duty claims are in those cases preempted?
I think so. I can't think of an example. That's why I said, I don't know that I'd agree with you as cleanly, because I can't think of an example standing here today, though.
Mr. Martin, I know we've kept you beyond
No,
your time,
it's okay.
but the focus has been on the fiduciary duty claims. I have a question about the prohibited transaction
Yes.
claim against the directors and officers. How do you get around Allen?
That's a great question. In terms
This
of...
seems factually, other than the loan, which wasn't involved here,
Yeah.
how do you get around the broad holding of Allen on the prohibited transaction?
Give me 1 second.
Okay.
Sorry.
And just saying Oshkosh isn't going to do it.
So look, here's my basic take with regard to it. There's 406 and there's 408E, right? So, and you're referring to the Allen opinion. And I think the holding of the Allen
On the prohibited transactions, not the fiduciary duty
Yes,
aspect.
and I think the issue there is that it's an affirmative defense in that case.
Correct.
Right, so I'm with you there. In this case, they pled themselves out of court. So if you
How
look
so?
at the complaint, the second amended complaint, and I'll give you sort of exactly where it is. It's paragraph 186 of document 36, which is page number 321, and it is within count 21, the first prohibited transaction thing. They plead that these transactions are not exempt under ERISA 408 because the purchase was not for adequate consideration. And with
Could you
regard
go back
the-
to the microphone, please? You're
Sure.
stepping away.
Sorry about that. So, paragraph 186, they plead, I'll just read it, that these transactions are not exempt under ERISA 408 because the purchase was not for adequate consideration. And they do it in the other paragraph that they have the exact same language on is paragraph 1139. And those are the two prohibited transaction claims against my clients, the directors and officers. The reason I say that they pled themselves out of court is this. Their core theory with regard to why the exemption does not apply, 408E, is that there's not adequate consideration. their core claim with regard to why there's not adequate consideration is the fraudulent inflation of the stock price over a long period of time, which is fraud that is not pled with particularity in this case. So I think that's how the 406 claims drop in this case, and that's how you make it consistent, or it is consistent with Allen.
So you're saying they haven't pled enough to establish that the consideration wasn't adequate?
Correct, and they took the burden, they took the burden upon themselves. This is why I say pled themselves out of court, because they decided in their pleading to take on the 408E issue.
So it would come back to 9B.
Yes.
On the prohibited
It ultimately
transactions.
collapses back to
Okay.
the 9B analysis. But that's how you address the Allen case, because, if you want to take on the affirmative defense, and, that's fine, but then you have to take it on.
Right. Thank you.
Thank you.
Mr. Riffey? Good morning.
Morning. May it please the court, good morning. My name is Matthew Riffey, and I represent State Street. I would just like to briefly focus on a couple key points. The first is the statute of repose, which bars almost all the claims against State Street with the exception of the one December 2012 valuation. And that's because plaintiff's fraudulent concealment allegations are especially deficient as to State Street because the complaint does not contain any allegations of an act of concealment intentionally undertaken by State Street. There's only 2 statements attributed to State Street in the entire opening brief or complaint. They do not come close to plausibly alleging an affirmative act with specific intent to conceal. Given the lack of allegations concerning State Street, in its reply, plaintiff attempts to make State Street responsible for statements or actions of others because it had the authority to review or approve certain documents. But this argument was not mentioned in his opening brief, thus it should be forfeited, as he acknowledged it wasn't in there in footnote 15 of his reply. But regardless, simply alleging that State Street reviewed and approved documents without any particular allegations as to who, what, when, or why does not satisfy Rule 9b. And the argument is also foreclosed, as you already discussed this morning, by Martin's rule that there must be some affirmative act. Mere silence is not enough. To the extent plaintiff is seeking to rely on self-concealing acts or the valuation itself, as this court explained in Martin and Laskin, fraud claims don't receive the benefit of ERISA's exemption simply because they're fraud claims. There has to be genuine acts of concealment. And here, there's no plausible allegations that State Street actually subjectively knew the valuations were false, much less that it communicated the stock value as part of some trick or contrivance to cover
But
its
didn't
tracks.
the district court overstate things, though, when it tried to create, a sharp distinction between the underlying fraud and acts of concealment? I mean, there's a lot of overlap in the real world.
Certainly. I don't think the district court overstated it, as is clear in Martin, which is still good law, and restated in Laskin. There has to be some genuine act of concealment. It can't just be the fraud itself. There has to be something to conceal. Martin gave an example where the fraud was the creation of a dummy corporation to conceal kickbacks, which was the fraud itself. There's nothing like that alleged here.
Right. I mean, there's nothing more extreme, but what is alleged is, I guess, failures to dig into things enough, failures to, deliberate decisions to skew the evaluations in an upward direction.
I don't think there's any deliberate decision that's alleged against State Street to skew in an upward direction, as State Street was just the trustee.
They're the trustee,
that was
right.
reviewing the appraisals and relying on the appraisals from the independent expert, the appraiser, which brings me to the second point. The one stock valuation during State Street's tenure that was not time barred in plaintiff's prudence claims generally against State Street. We don't believe the district court applied a higher standard of pleading than articulated by Supreme Court, by the Supreme Court or this court in Albert. And it didn't apply, and we're not arguing for a per se rule that all an ESOP trustee has to do is hire and rely on an appraiser. What we think the district court correctly did was apply the context-sensitive scrutiny that it needs to apply and found that plaintiff's claim against State Street didn't go from plausibility or from possibility to plausibility.
I know we have all these metaphysical
Sure.
differences, but so I understand you to be saying then that you're not relying on a statement that just because Stout was hired, you're home free.
No, as the Seventh Circuit has stated, it's highly relevant. But no, that in itself does not get State Street home free. It also complied with planned documents, as the court found there was no allegations of kickbacks or any logical incentive for State Street to defraud or to not have a sufficient process. And I think the context here is also very important given the sprawling allegations and the 17-year period that this case covers. Appian continued to operate for 17 years after the ESOP was formed, or nearly 17 years after it was formed, which distinguishes this from the ESOP stock cases like Allen and other cases where as soon as it's formed, the stock drops 50%, 100%. That didn't happen here. The stock valuation went up until the Great Recession. It decreased in response to outside factors. And then to the extent Appian ultimately went into bankruptcy, it was only after the sale of Encapsus, the most profitable wing of the company, which happened in 2015, long after State Street
Yeah, they were gone.
was still
but-
there.
yeah.
Thank you.
All right, thank you.
Ms. Smith?
Morning, Your Honors, and may it please the Court, Barbara Smith for Reliance Trust Company. The District Court below correctly dismissed all of the claims in the complaint against Reliance, and I'm happy to walk quickly through why that's so as to each claim in the complaint as related to Reliance, if that would be useful. But I don't want to belabor the Court's time. I know you're hearing from a lot of advocates, and you have a lot of briefing. There's a heavy paper load in this case, as you suggested, Judge Wood.
No, I mean, which is fine. I mean, it's a complex case. So, you know, it's a civil procedure, either nightmare or dream, depending on
Dream, yeah.
whatever you want to say. But your basic position, again, is that the pleadings themselves are inadequate. That's an issue on which our review is de novo, of course.
That's right.
We're going to look at that complaint and see if knowledge of another fiduciary's breach has been pleaded adequately, for example. We haven't talked much about that. With respect to the securities laws, we haven't talked much about them either, but we all understand that this is PLSRA territory. But what about the co-fiduciary liability? Could you say a word about that?
Sure, absolutely. So in order to state a co-fiduciary liability claim, the plaintiff would have to allege that Reliance knew of a breach by another fiduciary. That affirmative knowledge is an important component of the co-fiduciary liability language in the statute. It's clear from the statute. It's been well established in a number of other cases in other circuits, and I think a contrary holding that something less than actual knowledge here would create a conflict that maybe the court doesn't want to walk into. So if we take that as the baseline, that you have to establish or allege actual knowledge, there's nothing in this complaint aside from the conclusory allegation that there was knowledge. There's no plausible...
Which is okay, right?
Well, you do need a plausible fact to support that conclusory allegation of knowledge. It is the legal standard is knowledge. The fact that has to support it in the complaint is what is absent here. So it's not enough to say there was this, particularly in this case, there's not enough to say there's this 17-year ongoing fraud and Reliance knew about it and therefore can be liable as a co-fiduciary. That is not sufficient to have alleged a fact to establish knowledge as related to Reliance.
So you're saying it may meet Rule 8A, but it doesn't meet Twombly?
It doesn't. It is not. There's no plausible fact to support an allegation of knowledge with respect to Reliance because there are just no facts about Reliance's knowledge either way. There's just the conclusory statement that Reliance knew.
Yeah, the troublesome thing about that, once you're in Twombly territory, and this is just inherent in the word plausibility that the court chose to make the pivot point here, is the district judge needs to read this complaint with an open mind. You know, plausibility doesn't mean probability. You know, maybe it means well less than a 50% chance of winning. The court has had all sorts of statements to that effect. So there's that, but then the court is going to be looking at that and saying, does this make sense to me? You know, and does that go over the line for the 12b6 stage? Because the court is not supposed to be deciding who would I think should win?
Or in the words of Allen as related to the breach claim, can I infer an imprudent process based on the facts as alleged in this complaint? And I think with respect to the ERISA breach claims in particular, the prudence claim, for example, there are two theories in the complaint why Reliance could be liable. The first is this fraud-based theory. You knew of the fraud and you did nothing. I think you run squarely into 9B problems with that particular theory of liability. The other, of course, that they've alleged in the complaint is that the face of the valuations are so obviously erroneous that we must conclude there was an imprudent process.
Or at least at some point along the way, maybe not year one when there's the overstatement of the value, but as the process develops, they're in a position, they're the trustee, they're in a position to see what's going on and whether it really adds up. They've seen the 10Ks, presumably, they have some duty to sit there and be something other than a potted plant.
That's absolutely correct, Your Honor, and I think it's important to keep in mind with respect to Reliance, they came on as independent trustee many years, decades after the alleged initiation of this fraud for a very...
And do you think that exempted them from taking a look at what had happened up to that point? I mean, if you were to hire a new independent auditor for a firm, is that new independent auditor entitled to just start from the day that the firm was engaged, or does that new independent auditor need to look at prior books to make sure that the firm is dealing with reliable data?
Well, whether the valuation firm should have looked at different valuations, I think, or different data would be a question for them. Whether Reliance, as the independent trustee, adequately asked the right questions.
Right, ask the right questions, that's right, monitored.
The question there is, for the period of time during which it was trustee, did it ask the right questions? Not did other trustees in previous eras ask the right questions, but for the two valuations that occurred during the brief period of time Reliance was in this case, did Reliance do what it was supposed to? And there, I think the question the court asks is, what are the allegations in the complaint with respect to the prudence of Reliance in particular? And on the one side of the ledger, you have very prudent fiduciary conduct. You have hiring an independent appraiser, you have asking questions of that independent appraiser, you have notes on a meeting that address the very complicated issues, Judge Wood and Judge St. Eve, that you mentioned earlier, about things like the company's debt. Those are indicia of prudence. It's not it doesn't establish prudence, but it suggests an inference of prudence. On the other side of the ledger, there are no allegations, there are no process-based allegations that Reliance was imprudent. It is just the plaintiffs say so. It is because we would have done the valuation differently, you should have asked the questions we would ask to come up with a different conclusion. And that's, we suggest, not enough.
They're basically saying that when Mr. Lyon undertook these things, it's like he turned over a rock and he found all sorts of things crawling underneath it, and it wasn't that hard for him to do it. So that would lead to an inference that's the opposing inference, right?
Well, it may be the case that if you come into this case during the time of the bankruptcy in 2015 or later, that you might look at projections leading up to that time period and come to a different conclusion. But if you look at the projections just in 2012 and 2013, which is all that you look to with respect to Reliance in particular, you don't have that same problem. And again, the question is, at the time they reviewed the valuation reports in 2012 and 2013, did they ask the right questions? Did they probe on important issues? And the notes that the plaintiff has put in the record of the meeting with the valuation firm suggest the answer to that question is yes, which leads to an inference of prudence, not an inference of imprudence. And I think particularly in a case like this, as my co-counsel said, the plaintiff has pled themselves out of a complaint because they're relying on this decades-long fraud. If they had written the complaint differently, if they had targeted their claims more narrowly, maybe we would be in a different place. But you can't allege a decades-long fraud and then try to walk back from it and say, all of my ERISA claims related to you sometimes rely on fraud and sometimes don't. You look, Judge Wood, as you know, at the complaint as a whole, and all of the allegations in the complaint, not any one allegation in isolation. And in light of that, I think that makes the allegations against Reliance here particularly improbable to the extent they exist at all.
Thank you.
Thank you.
Mr. Golombek?
Good morning. Lars Golombek on behalf of Stout Rhesus Ross and the individual Stout defendants. Stout played a very limited role as the appraiser for the ERISA trustee and provided valuations for ESOP administration purposes, which the Halpern Court concluded served as central ERISA function. In doing so, Stout provided no services to the company or to the plan. Looking at the specific claims brought against Stout, the Stout defendants, the federal securities fraud claim, the district court properly concluded that it should be dismissed for failure to plausibly allege scienter. And the district court found correctly that there was no cogent explanation for why Stout would commit fraud, not negligence. We can talk about that in a second. Fraud. First of all, Stout received a fixed $50,000 fee each year for the semi-annual evaluation and prepared, so $100,000 annually. The district court, though, went beyond that and said, let me look at the circumstances overall and in the context, and found that there were no fraud-based reasons for Stout to find a allegation of scienter, a plausible allegation. And I want to get to a couple points that you brought up earlier, Judge Wood. One is about stock price. Now, at a high water mark, Stout valued the shares of stock at $33.41 a share. Within a decade, we went from here to $6.85 a share. That's an 80% decline in stock value. If the allegation is Stout was trying to prop up the value of shares of Appian stock, they did a lousy job of it. Another key data point. There was a sale of a business division in Capsis. So Stout valued that business division separately each year. At the time of the sale of Incapsys was sold for $208 million. In that same year, Stout had valued that business division for $166 million. That's an over $40 million difference. Importantly, Stout used the same projections that the company had provided to them in the ordinary course of business in helping to develop that price. And so the market price was $40 million higher than Stout. Again, the judge looked at this and the circumstances, again, to determine whether there were fraud-based reasons. We talked about pension debt earlier. Each year, Stout's report disclosed the pension liability and its treatment of the pension liability. And I understand from appellant, what they say is an irregularity is that their valuation professional would take the enterprise value, the value of the subject company as a whole, and subtract the pension debt. What Stout did instead is two things. One, it took the projections provided by management, which assumed a pension expense. So that was the basis for the discounted cash flow analysis. Stout didn't stop there. They also conducted what we would call a guideline company method. So they looked at comparable companies traded on the stock exchange that had a pension debt, and they picked those companies with a pension debt. So there was a like comparable because Appian wasn't essentially publicly traded. And so all things being equal, the multiples used to derive a value from this separate analysis would be lower. And they went one step further. They took that lower multiple, and that was a basis for deriving what we call a terminal value, which was looking at valuing the company into perpetuity for purposes of coming with a concluded value. So I understand, and we've heard references to irregularities in the valuation. That does not constitute fraud-based reasons. I want to turn quickly to one other, the state law claims against Stout. For negligent misrepresentation, and those claims under state law, and there's a state law fraud claim, those claims are preempted. Halpern said this is a central ERISA function. Stout's doing the same thing for the same trustee, preparing semi-annual evaluations. The claim here for preemption is even stronger because, as Halpern noted, it's in a footnote, but they noted where here you have an independent fiduciary bringing a claim, ERISA provides for a cause of action under 502A3 of ERISA against a non-fiduciary like Stout for knowingly participating or knowingly concealing a fiduciary breach. That is a further grounds for preemption of these state law claims against Stout.
Thank you. Mr. Kimberly?
Thank you, Judge St. Eve. This is a complex case. It involves multifaceted allegations and a complex statutory scheme. I hope to persuade you that with respect to Houlihan, the case can be affirmed for a very simple reason, and that's waiver. As a starting point, I understand my friend on the other side now to concede that the ERISA claims as against Houlihan are off the table. They're waived. That appears on page 12 of the reply as well. So that leaves only the state law claims. And our position is that those claims are also waived twice over. And I'll start with the simpler reason, which is simply that they weren't briefed before this court. We had an overlong brief filed as an opening brief, and yet in all 20,000 plus words, not a single word was devoted to the question whether the state law claims should be reversed on their merits and not just on the question of ERISA preemption. So, you know, this court in cases like Mayer and Blagojevich has been very clear that when there are two independent grounds on which a district court bases its ruling and the appellant challenges only one ground and not both, it would be impossible to produce a different outcome by reversing on just one. And that rationale applies here very straightforwardly. In their reply brief, in his reply brief, Mr. Lyon asks this court effectively to disregard the waiver, citing Blagojevich as an example. But in Blagojevich, the government expressly waived the waiver at oral argument. We are not doing that. I would add also that there are elements of the state law merits that have now been raised for the first time in the long history of this litigation in the reply brief before this court. And that is precisely why it's important in this circumstance to enforce the waiver, because there are new authorities being cited, new arguments being made, and Houlihan has had no opportunity to address any of these arguments, as to which we have very strong rejoinders, but no opportunity to respond.
Can you give an example or two of those arguments?
Certainly, Your Honor. I'd point the court to page 20 of the reply brief, the discussion about the duty to disclose. These are all new arguments. We've argued all along that there is no duty to disclose, and it's we've not had an opportunity to address this, the new citations to authority on this point. And frankly, that's all the court has to say is against Houlihan. Houlihan's role in this case ended in 2000 when the ESOP was formed. Even if the court were to get past the question of waiver, the question of timeliness is even more obvious in this case than it is with respect to any other defendant. Unless there are questions about the merits or the waiver question, we'd ask the court to affirm as against Houlihan in a single sentence saying that the claims are waived.
All right, thank you. Mr. Hume, back to you.
So first I want to address Mr. Martin's argument that there were no arguments that the D's and O's were involved in the valuations, that they weren't in the room where it happened. So we have pled in the complaint various ESOP committee meetings where they both reviewed the valuations, they suggested things to include in the valuations, and then they actively approved them. In addition, Stout was not actually independent. They were recommended to be retained by Houlihan in 2001 as Willamette at the time. In 2002, the D's and O's then recommended retention of Willamette. Same thing happened in 2005 when these employees moved to Stout. And then, importantly, in 2013, when Reliance took over as trustee, retention of Stout was a condition of their engagement agreement. And that's pled at paragraph 574 of the complaint, I believe. So that makes them not independent, and the D's and O's directly involved in this whole process. So in addition, Rule 9b, I'd like to really highlight
How does that make them not independent? If they're, just because Reliance wanted to bring along Stout to do the evaluations, how does that question independence?
Well, who are they trying to please here? The ones that keep hiring them? The D's and O's, who they've worked with for decades and are recommending retention of them. I believe that impacts their independence here. Now, with respect
But
to
it was Reliance that wanted to bring Stout along, not the D&Os.
no, I believe that was the D's
I
and
thought
O's.
that's what you said.
No, the D's and O's required them to retain Stout as part of their engagement. Now, with respect to Rule 9B, I think it's really important here that, that Mr. Martin has framed this as everything's based in fraud. And that's disregarding the elements of breach of fiduciary duty. Elements of a breach of fiduciary duty is there's a fiduciary, they breached their duties, and there was harm. Knowledge alone that the valuations might be inflated, that doesn't transform the entire allegation into a fraud allegation. And finding that it would basically turn all ERISA claims into fraud claims, and I think that would be a bad result. However, even within that, we have, in addition to that general breaches of fiduciary duty, we have breaches of the duty of loyalty, which expressly do not involve any kind of misrepresentations. There are no averments of fraud. We have against the outside directors in particular and the CEOs who were members of the board of directors as well. We have breaches of the duty to monitor. That's literally just a failure to, at reasonable intervals, check in on the fiduciaries they appointed. Again, that does not involve fraud in any way. With respect to their knowledge regardless, we've pled extensive facts about Bemrose Booth, which we think put the D's and O's on notice that the pension liability should be deducted. We have expressly, for the outside directors, the claims are only stated as of that time, December 2007 on, with the exception of count 18, Mr. Sewin, who joined later, and his claims are only within the statute of limitations time period. Again, these are outside directors. We contend that the Bemrose Booth facts put them on notice because there they were deducting about $15 million in Bemrose Booth's, subsidiaries' pension liability from Apvion's debt as a whole.
But there was argument, though, that the Bemrose Booth situation was somewhat different. It wasn't so much future liabilities, if I'm remembering correctly, that it was distinguishable.
I believe State Street made that argument, but that was pure attorney argument.
Well, don't say that. I mean, we're conducting a de novo review ourselves, and I guess we're all lawyers, so maybe that's something. And if they are factually distinguishable, then maybe the lesson wasn't as clear as what you're suggesting it was.
I mean, Stout here made most of their arguments outside, substantive arguments outside of the pleadings, and we submitted expert reports to the district court and requested conversion to summary judgment. And the court declined that and decided the issues against them solely based on motive. Our experts disagree with that principle that you don't have to deduct the pension liability except for this near-term liability like that. So that is...
So you're essentially saying on a 12b6 lens, we have to assume that this was not a sound practice.
Yes, I mean this is something
facts could show that it was later, but we would have to take that assumption for you.
Yes, I would expect this to be, a battle of the experts later on, but I don't think that's appropriate to decide on a 12b6 motion.
With regard to the issue of preemption as to the state law claims against the DNOs, can you identify a obligation that state law imposes that the plaintiff would not be able to enforce or effectuate under ERISA?
Yes, I believe we pointed to, ERISA is about enforcing benefits. Money's due generally with an ESOP valuation. It's cases say it's the difference between the price paid and the value stated. Our state law claim is directed to things like corporate waste, the Encapsis sale, which we never contended the Encapsis sale wasn't for fair market value. We don't believe it's, the Stout's valuations of that are as important as Stout says. However...
But isn't that part of your ERISA fiduciary duty claims as well? That by not exercising their role properly or adequately, they deflated the stock value, and that also harmed the ESOP participants?
I mean, I think the ERISA behaviors and obviously I think that's a question of discovery, what was actually being done in a fiduciary capacity as well. But I think these decisions to sell Encapsis are not necessarily fiduciary decisions. And, we'll figure that out as we go, basically through discovery, when we look more at what was actually discussed in these meetings, how this lens was viewed, whether they were following a proper process, whether it was an ERISA capacity at all. But it did harm the ESOP as both the shareholder and as the ESOP itself as an ERISA benefit plan through the value of the shares. And I believe, as this court explained in Halpern, ERISA is meant to tolerate these kinds of dual hat liabilities, and we should be able to pursue it for damage to the shareholder as well.
But there's also the rationale in the cases that talk about how the conflict preemption provision is designed so that a plaintiff could not basically get another alternative way of obtaining the same relief that the plaintiff would be able to obtain through ERISA.
The question is it the same relief or not? And I think that's attempting to get at damage to the corporation that only very indirectly would have flowed down into the stock value. And the stock value itself is, again, not really a full reflection of the balance sheet. It's an artificial closed number that they've created over time.
So you've also alleged a derivative action, right?
No, we do not have a derivative action. That was reserved in the bankruptcy court to the creditors committee. Yeah.
Thank you.
Right. So I wanted to further address under Rule 9b the prohibited transactions claim. That claim, it's ERISA 406A. This court's described it as a bright line rule in Allen. It's a per se liability, a per se violation. And the elements are a fiduciary knew or should have known that a transaction violated ERISA 4A and the fiduciary caused the transaction. Those are the only elements.
You're only pursuing that against the directors and officers, correct?
Correct. And there's been no dispute that they caused the transaction. The Second Amendment complaint describes in detail what those transactions are. There's appendices to the complaint, which lists each of the transactions, lists the D's and O's there at the time, lists what the transaction was for and the approximate date. So even if that claim needs to be pled with particularity, those elements are pled with particularity. I'm very concerned about the idea of bringing all of the elements of a fraud claim into these breach of fiduciary duty allegations, where it's not necessary for the claim, and if they, their actions don't necessarily carry out or involve averments of fraud. The ones that do involve averments of fraud, misrepresentations here, are pleaded in specificity. We've quoted from the communications. However, their actions behind the scene are not statements. And the same applies to the trustees. They're attempting to import knowledge requirements and transform knowledge allegations into fraud allegations, and that's simply not warranted under ERISA or under the basic elements of breach of fiduciary duty.
Thank you, Mr. Hurd. The court will take the case under advisement. Thanks to all counsel. The next case for oral argument this morning is Artis versus Santos, Appeal 22-2619. And Mr. Cooper should be appearing remotely.
Okay, I believe I'm unmuted. Good morning.
Good morning, Mr. Cooper. Can you hear me okay?
I can. Good morning, Judge Saney.
Whenever you are ready, please proceed.
I am ready. Good morning, judges. We're here today for three reasons, at least from the perspective of the plaintiff. And the first is that Mr. Hayward was permitted to testify. It's plaintiff's position that Mr. Hayward's report and his testimony did not comport with Rule 702, nor with Daubert.
You're not challenging Mr. Hayward's qualifications, correct?
I'm not challenging his qualifications to the extent that he's an expert as to insurance, but Mr. Hayward's testimony wandered into the area of bonding, and that's where plaintiff has a real concern. Does that answer the question, Judge Wood?
Yeah, go ahead.
Okay. So, Mr. Hayward, granted, is a skilled witness and has expert knowledge as to insurance, but as to the issues in this case, specifically as to bonding, he did not have that expertise. Mr. Hayward, in the opinion of the plaintiff, should have never even reached trial.
This sounds like something different than you argued before the district court. Did you raise this issue before the district court that Mr. Haywood was not an expert in bonding and couldn't give this opinion? Your opinion, your challenges in the district court seemed more grounded in the type of opinions that were being given and the fact that he was relying on his expertise in order to give those opinions.
Yes, I agree, and I do have my district court brief, and I do have some testimony, or I should say, I have some transcripts, not all. I can tell you that I can tell you as an officer of the court that I remember challenging Mr. Haywood's testimony and arguing that he was giving testimony as to issues for which he had not been disclosed.
Well,
And perhaps
let me ask you this, Mr. Cooper. I mean, with respect to this bonding business, it does appear that there was some cross-examination where perhaps you were pointing out that he had relied in part on an online article about bonding. But it seems to me that this is all within the scope of the district court's discretion, and it would go to the weight of his evidence, not the admissibility of his evidence, especially when a contemporaneous objection about going beyond the scope of the Rule 702 certification doesn't seem to have been made.
All right, Judge, I don't have the transcript in front of me. I certainly recall having objected to some of the answers by Mr. Haywood.
Well, it seemed more like, do you really know about bonding if you're looking at online articles about it? But this was in front of the trier of fact, and so without saying, without asking for a sidebar or something, without getting an instruction from the jury to from the judge to disregard something that would have alerted the district court judge. That's the problem.
I understand, Judge.
Okay.
No, I certainly understand. And as I indicated, I felt as though, or plaintiff felt as though, Mr. Haywood's testimony was in some part granted based on his own expertise, but otherwise on internet clippings, random articles that he had found on the internet.
But if you are an expert, though, and surely Mr. Haywood was, he had 40 years of experience in this. He had handled insurance brokerage services to municipalities in particular. Kumho Tire says that experience is a perfectly legitimate way to demonstrate the expertise of a proffered expert witness. So his main message seems to be that if you employ somebody with this kind of criminal record, it's going to cost you one way or the other. And it seems that he had plenty of expertise for that.
Yes, Judge. The other issue, one of the three issues, is the statement by one of the prospective jurors. And the district court's opinion in document 163, page 9, certainly is helpful since I don't have the questionnaire, and I assume Mr. Tolbert doesn't have the questionnaire.
Can you speak a little bit about that? How can we even decide this issue when the documents that are central to it are not in front of us?
I understand, and I've never had a situation like this before, and I wasn't sure how to handle it. I did ask the district court to provide the document, and my understanding was the district court would have sent the document up. But I have never been in a situation where I've challenged a juror's qualifications and then had to somehow get my hands on the questionnaire.
The district court addressed the questionnaire in its post-trial rulings and laid out
It did.
question and answer. Wouldn't that be sufficient for us to address it? And we
Well,
also
it's
have the
certainly-
testimony during voir dire and the questioning of the juror on that questionnaire. Wouldn't that give us enough?
I don't think it would give enough, but I'm looking at page 9 of 163, and
You don't think it gives us enough? I mean, you're the one challenging this, Mr. Cooper.
I
So-
don't think so. No, I think.
Then
we
how
need the
can you?
questionnaire.
Then how can you challenge? Then how can you raise this challenge? I'm trying to help you out here.
It was a
understand.
friendly question, trust me. And I guess the way I would have phrased it is whether the parties have any reason to question the accuracy of what the district court judge put in her opinion, because in some sense it seems that what the questionnaire said is de facto stipulated. Is there any dispute that she has recorded this properly in her opinion?
No, Judge Frickman has recorded properly. However, this is a small smidgen. This is not what the juror actually wrote. I mean, the way I see it, plaintiff is entitled to the questionnaire in order that plaintiff can best challenge the questionnaire and challenge, that is, make a stronger argument that juror should have been disqualified.
Are you withdrawing your argument then?
No, I'm not withdrawing the argument, Judge. My position is I had, in my opinion, I had an obligation to make the argument, and I made every effort to try to get my hands on the questionnaire. I don't think it would have been appropriate to abandon the issue simply because I could not get my hands on the questionnaire.
Then what is it you think we should review to make a determination on your challenge? Because you've just responded to both Judge Wood and myself that you don't think we can rely on the voir dire and the questions asked about the questionnaire during voir dire, and you don't think we can rely on the district court's post-trial ruling that lays this out. So what can we rely on from your viewpoint in assessing your challenge to the juror?
Well, I think the questionnaire is needed, and I'm not saying that everything that you just listed can't be relied upon. It can be in some part, but I think we need the questionnaire. We need to see the questionnaire. We need to see what the juror wrote on the questionnaire.
But
So
didn't
I'm
you
saying
drop
that-
the ball on this? I mean, as I understand it, the last communication between you and the district court happened after the district court said, I can't send this up, it's not part of the appellate record, for purposes of Federal Rule of Appellate Procedure 10A, then sort of thinks maybe the catch-all provision of 10E3 applies, but the district court, as I understand it, ultimately said that you had to present your motion to the Seventh Circuit Court of Appeals for disposition, but you never came to us and said that this kind of weird, not quite in the record thing needed to be added. And so what happened is you filed a motion, or Santos files a motion to dismiss the appeal. A motions panel of this court denies that motion, tells Santos he's free to argue, you, in other words, are free to argue that our review is precluded. But it's all very strange, and I don't think was very cleanly presented.
Again, I haven't had a situation like this in the past. The way I understood the district court's order, at least this is a reasonable interpretation, that the district court would automatically cause the questionnaire to be part of the long record. And I assumed coming here this morning that the panel has had an opportunity to look at the
How
questionnaire.
could you assume that when the district court denied your motion to supplement and you never asked us to supplement?
Because the way I understood the district court was that the district court was saying that this is something that's automatic and that attorneys would not be provided with the questionnaire.
That's
And
not
so
what they
if-
said, though. I mean, that's not what she said. She said that this
I
questionnaire
understood
isn't
that.
part of the record, formally speaking, and we would need to supplement, which she felt she couldn't do, but perhaps we could.
Yeah, I'm sorry, Judge, I did not interpret it that way. I interpreted it as the questionnaire would make its way to the panel, but for whatever reason, the attorneys couldn't see it.
Mr. Cooper, you're into your rebuttal time if you want to save some.
I'll just move quickly. The other issue is the special verdict form. And, you know, there are a variety of reasons why a special verdict form is needed. One is complexity. I don't believe that there was anything so complex in this matter that required a special verdict form. I do believe that 3 and 23 were in fact confusing. I understand that they're model instructions. I get it, but it doesn't mean that because it's a model instruction and 3 and 23 are the same. In my opinion, it doesn't mean that jurors won't be confused. I mean, I think 3 and 23 needs to be changed. That's all I have.
Thank you, Mr. Cooper. Mr. Tolbert?
Thanks.
Good morning.
Good morning, Your Honors. My name is Michael Tolbert, and I represent Adrian Santos. And I'm going to respectfully ask that this court affirm the jury verdict that was reached in favor of Adrian Santos and deny any attempt for a request for a new trial for a few reasons. The first reason is the district court did not abuse its discretion in allowing Mr. Haywood to testify as an expert because he satisfied both Federal Rule of Evidence 702 and also Daubert standards.
Mr. Tolbert, on that grounds, on that issue, the district court, when the district court ruled on the issue of whether or not Mr. Haywood relied upon reasonable and reliable methods, just gave a one-sentence conclusion. Said, oh, and his methods are reliable. Is a statement like that sufficient for a district court to explain the reasoning that would trigger abuse of discretion, or should we look at this de novo given the fact that the district court did not provide any sort of explanation other than the bottom line, oh, the methods are reliable?
Your Honor, I believe that is sufficient enough. The response that they gave was sufficient enough because I believe under the appropriate standard, the district court had the discretion, and it would have to be shown that it's a serious error in judgment. And
but wouldn't you expect the district court to provide some explanation, reasoning for that conclusion? I find the methods reliable because of his experience and the way he applied it, and he looked at external factors, what have you. And here we don't have any of that, right?
Your Honor, in context, and when you look at the record in terms of what was presented and the painstaking detail that Mr. Haywood went through, first to not only qualify himself as an expert, but also to show the correct methodology was used. Specifically in the record, Mr. Haywood not only elaborated on his 40 years of experience in the insurance industry, but he also specifically cited to the underwriting process, which talked about analyzing risks, how insurance companies, and particularly bonding, when you're looking at whether somebody has a risk-averse profile, whether or not it would be a good risk to bring somebody on. There's so many problems that can come along with that. There could be surcharges, there could be increased premium, and Mr. Haywood went through that in painstaking detail, and I believe that in light of the testimony that was given from Mr. Haywood, the court felt comfortable enough qualifying him not only as an expert, but also finding that his testimony was reliable, which I imagine probably led to the brevity of the response because of the record was so robust with so much information that qualified him as an expert in his methodology. So that's the way I took it because of how detailed he was. There was really no question. And if you look at the record, Your Honors, one of the big issues that I had, and I believe most likely, why I believe that the expert issue really is a non-issue, is because Mr. Cooper didn't necessarily, he really waived the argument. His objection was non-specific, it was very general.
How could he waive the argument, though? There was a Daubert motion raised in advance, which was pretty detailed, and then before trial, right before trial, when he objected to Mr. Haywood taking the stand, he raised the same arguments that he had raised in his Daubert, and the court said it had previously ruled on the matter. And then when the question was presented when Mr. Haywood was testifying, he rested on his prior objection. I don't know how that could be waiver.
Your Honor, my position on that is he did file motions to exclude early on in the pretrial phases, but right when Mr. Haywood began to provide his testimony, I believe that his objection, and some of the points that was earlier raised in terms of specificity of what the judge should have probably said in terms of qualifying Mr. Haywood as an expert or finding his methodology to be in error, maybe we could have gotten more information if Mr. Cooper would have been more specific in terms of outlining exactly what he found wrong.
What else do you think he should have done at that point? Again, there was a Daubert raised in advance and a hearing on that, and before Mr. Haywood took the stand, Mr. Artis' counsel did reiterate his objection with some detail, and the court said I previously ruled on it. Once Mr. Haywood's on the stand in front of the jury, do you think Mr. Cooper or the attorney representing Mr. Artis should have gone back into all those issues again?
Absolutely, Your Honor. And
what
I believe
requires that?
Well, I believe that if you look at the case that I did cite that dealt with the waiver issue, let me see if I can find it. Let's see. It's United States versus Wynn. It's 845 Federal 2nd, 1439, 7th Circuit, 1988. Although it's an embezzlement case, Your Honor, and I do understand that that case is not necessarily completely on all fours, but the general concept of not having specific and having not general objections, the court found that that was a problem in terms of analyzing whether an objection was appropriate. So that essentially is our position here. There are reasons why you have to make specific objections. I believe Your Honors actually pointed out something that jumped right out at me at the beginning of this, is the same argument that Mr. Cooper raised about the bonding issue, which was never raised at the district court level and raised for the first time here, should have been raised specifically and in a non-general way before the district court.
But that's a separate waiver issue, though, by raising something for the first time on appeal than what you've been arguing about what was waived before the district court.
I respectfully agree with that, Your Honor, but I think the concept of being properly bringing objections before the district court to allow everyone to understand exactly what you're articulating so that we can have a clean record should be incumbent upon the person, particularly in this case when they're bringing an appeal.
So if we assume, though, that there isn't waiver, just for the sake of discussion, where does that leave your argument about Mr. Haywood's testimony?
Well, I believe, Your Honor, in my brief, waiver was one component of it, although it wasn't the main part. But I believe that even if you discard the waiver issue and you go through the analysis of, well, at first I thought that Mr. Cooper was kind of trying to allude to the fact that Mr. Haywood was not qualified.
Well, that's right. I mean, as I understood him, he was saying Mr. Haywood was qualified for certain things. You know, maybe he was qualified for certain kinds of insurance practices, but there's a whole different field of expertise that he wasn't qualified for, but he had turned to that in his testimony. I think that's a summary.
Right, and I would respectfully disagree with that. And to answer your question directly, where that leaves us is going through the methodology and whether or not what Mr. Haywood said satisfied the the standard. And
Well,
I
did he
believe
know
that
anything about bonding? I guess the bottom
Yeah.
line, that was the question.
Your Honor, that bonding and insurance, essentially what the bond is and what the testimony in the record was from Tom Dabberton and the insurance risk professionals who Mr. Santos consulted with before he terminated Mr. Artis. A bond essentially is just a protection if someone steals. No different than the crime policy that was at issue in this case. So really the terms are interchangeable, and I think that Mr. Cooper is mixing terminologies, but the concept is the same. Under the crime policy,
And that was in the record. I mean, the
that was in the
critical
record. Yes, that was in the record, Your Honor. But the concept is the same. If you steal from us, we need protection. Crime policy. If you steal from us, we need protection. Bond. The bond specifically deals with the individual, whereas the crime policy dealt with the entire clerk's office at the City of East Chicago.
Didn't
That's-
Mr. Haywood testify to that he had had experience with bonds
He did.
being issued
He did. He did.
during his 40 years?
Yes, during his 40 years, and he's a specialist in municipal entities, particularly like the one that Mr. Santos was managing, the clerk's office. He actually was the risk manager for the Lake County clerk's office, which is a little bit of a step above, although I don't want that on the record, but they're just
We
say
won't
that. Thank you, Your Honor. But let's just say that he insured other clerks' offices. He insured an airport. He was an unofficial risk manager for an entire city of Gary. So he was more than qualified, not only in bonding, but also insurance.
All right, so we basically don't need to worry that much about waiver if your primary argument is on the merits.
Yeah, I agree, Your Honor. I think that there's more than enough evidence to show that the methodology that he used was sufficient. If you look at the record, he went through each element of Daubert, peer review. He also talked about a zero rate of error. And the reason he got to that is because essentially under the underwriting process, what he would do is look at the crime policy and look at the condition. In this case, we had Mr. Artis, who had stolen $1.5 million previously in 2005 from the city, who ultimately hired him back before Mr.
The record doesn't show anything about why he is hired back. I was a little surprised.
Your Honor, the record is clear in terms of why he was hired back, and there was a clerk that Mr. Santos actually replaced by the name of Mary Morris Leonard, who hired Mr. Artis essentially as a favor. And that's what caused this whole problem. Mr. Santos enters the office in January of 2016. He tries to implement new standards, one of which I don't want people who stole $1.5 million working for me. And that's essentially what caused all of this. Once he found out that was the case, he terminated Mr. Artis. The claim was won for a First Amendment violation, and the record clearly shows, which bumps us against why this verdict should be affirmed, because it's more than enough if you apply reasonable emphasis to support the verdict. He showed not only that Mr. Artis have a felony, but he also showed the letters as well as the communications that he had with insurance professionals about why this was not a good idea to keep Mr. Artis. So we believe that that's more than enough to support the verdict. With that being said...
Do you have any way out of this procedural snarl we're in with respect to the challenge to the juror? Is it your position we should just consider it, not capable of decision, or should we go on the record that we have?
Your Honor, I would, that's the reason why I filed my original motion to dismiss, because I believe that really under the RK Company versus SEC decision, it's 846 4th F 3rd 846 7th Circuit 2010. Basically, you need to present the appropriate record for appellate review, and I believe in that case there was a little bit different. I think there was deposition testimony that was not provided for the court to consider. In this case, it is unique because we have a jury questionnaire. My position on that is that Mr. Cooper didn't, which is the reason why I filed my motion to dismiss the appeal, he didn't take the appropriate steps to actually secure the questionnaire. Or I can't speak for Mr. Cooper, but if it were me, if that was a big enough issue for me, I would have asked that the court put that juror questionnaire to the side and sequester it. And I'm sure the court would have done that, just like any other exhibit book, just like anything else, if you believe that that was going to be an issue for appeal.
Mr. Tolbert, that may have been a better way to proceed, but why can't we rely on what the district court included in the post-trial motions, where the court included the response to the question in the questionnaire?
Your Honor, I would welcome that you rely on that part of the record, because I believe under U.S. versus Allen, the Allen case, I still believe even if you relied on what happened at the district court level, Mr. Cooper or Mr. Artis the appeal fails because the juror gave unequivocal information to everyone in that courtroom when we tried this case.
You aren't challenging, I'm sorry to interrupt, but your time is dwindling.
Okay,
you
sorry.
aren't challenging the accuracy of what the district court judge represented in the post-trial motions that this juror said on the questionnaire.
Well, what was said...
This isn't addressed in the brief, so I want to make sure I'm not missing something.
Right. So, Your Honor, for fear of misstating what actually happened or what was said in the questionnaire, I think what the district court actually provided us was an offshoot of what Mr. Cooper believed the issue was, which essentially...
She included a quote
That's right.
from the
It's
questionnaire.
set off and quoted, yeah.
So more than just a summary of what Mr. Cooper had argued, I understood her ruling to be providing the precise quote given by the juror in the questionnaire that's at issue here.
I would agree.
In that additional comment section, right?
I would. I believe that wasn't the entire.
It's not the entire questionnaire,
but it is enough.
The quote at issue.
Your Honor, I don't have a problem with the court relying on that, because I still think that under the U.S. Under the Allen analysis, because the juror essentially was committed to saying that she could follow the law, and in fact, under Mr. Cooper's very, very rigorous questioning of that juror in voir dire, she specifically said that any decision that I make would not be based on color. And in fact, if you look at what her comment was, her comment specifically dealt with fairness, and I think it has something to do with African Americans being pulled over in certain areas more than other areas, which had nothing to do with our case, which was a First Amendment retaliation claim, which dovetails nicely into the Allen case, because Allen found that the statement that was made in Allen by the juror was marginal at best because it had nothing to do with the case.
Right. Okay. Thank you, Mr. Tolbert.
Thank you, Your Honor. Appreciate your time.
Mr. Cooper, you have a couple minutes. You're on mute. There you go.
So, yeah. Judge, I just want to go back to something I said earlier. Judge Springman is a great judge. I have a great deal
Wait,
of
one
respect
second, please.
for her.
Could you do the clock, please? Thank you. Go ahead. I'm sorry. I didn't mean to interrupt, but they didn't start the clock. So go ahead, please.
Judge Springman did a wonderful job presiding over the trial. It was a grueling trial. And I can tell you that what's in document 163, that her recollection, it's accurate. I
didn't take it to be a recollection. It seemed to me that she was taking it off the questionnaire because it's a quote.
That's what it looked like. Yeah.
No,
Either way, you're saying you're not contesting it, though. So you are. I'm taking this as essentially a stipulation by both parties that we can rely on what Judge Springman wrote down.
Judge, we can, but I don't think it's enough. I believe that the court would need to see the question in its entirety.
But we have the whole voir dire. We have the follow-up, the transcript, in which the judge is exploring what exactly did this juror mean by writing these comments. Why doesn't that get us as far as we need to go?
Judge, I don't think it does, but my biggest concern was I believe that I want to make clear that Judge Springman is is a forthcoming person, is a truthful person, and what she put into document 163 is accurate.
Okay. I think that works to your benefit, Mr. Cooper, because then we can address the issue.
Yes, Your Honor.
Is that all you have?
That's all I have.
Okay.
I thank everyone for
Thank
hearing
you.
us this morning.
The case will be taken under advisement, and we are going to take about a 10-minute break before we pick back up with the next case.
We know, of course, that federal employees receive the benefits of the Westfall Act, which is included in Title 28, 2679, but this case involved what they refer to as deemed employees, who are referenced in Title 42, USC 233. I don't believe the court has ever found a case that found that Section 233 didn't apply, that the Westfall Act didn't apply to cases under Section 233. Both statutes...
I don't think we've said either way, specifically.
I think, you know, it's been said, and I can't deny that it's been mostly dicta. But what I think is interesting is the fact that every case that has been, that issue has kind of been in the background, the court has always seemed to assume that 233 does include Westfall.
Well, isn't that because the United States, when it removed or when it substituted in those cases, cited to both?
Very often the United States did cite to both, but the fact of the matter is all those cases are cases that were where it was a deemed employee. The fact of the matter, they were all deemed employee cases. And when this court looked at those cases, I looked at them right before just the other day. The government notes that we refer to three particular cases. We refer to the case Blanche that was removed based on the fact of deemed employees. And the court in writing, and I know it's dicta, but the court in writing, because I think the court is just interpreting what seems logical. The court says in reaching that decision, the savings provision allows plaintiffs to bring the claims to bring the claims and proceed as if a civil action is filed within 2 years, and basically cites the Westfall Act.
So let me run this thought by you. We have the Westfall Act, which applies to employees, and we have Section 233, which is for the public health service, et cetera, and creates this category of deemed employees. And when you look at Section 233, there are a couple of things I would say. One is that it obviously does incorporate parts of the Westfall Act, but we also know from the Supreme Court's decision, in however you pronounce this, Hui against Castaneda, that it doesn't just wholesale carry the entire Westfall Act into itself, because the court specifically says it doesn't in that case. It was a different issue. It was a Bivens issue. Right. But that's okay. And so I think this might simply be a question of whether this particular tolling or extension of the time to file an administrative claim part of the Westfall Act is one of those things that Section 233 does incorporate, or whether it isn't. Because if you look at 233A, it begins by saying the remedy against the United States provided by 1346 and other stuff. I mean, it tells you that we're going to look to Title 28. Obviously, 233 is in Title 42, so it's a separate thing. And so I guess some of it seems to be incorporated, but some of it isn't. And then it causes me to look at the difference in the statutory language between 233 and 2679. And there are some real differences.
There are some real differences because there have to be some real differences, because on the one, there's some steps you're going to have to go to determine whether somebody is a deemed employee. And there's certain things that have to be done that are just not going to be relevant when it is an actual employee. Your Honor, basically, I was actually going to make that point that you made up top about the fact that both the statutes refer to the 233 refers to sections 1346 and sections 2672.
Right.
And
starts right
so
out
does.
Yeah.
And in 233, the removal section, it says, you know, once a case is removed, it proceeds as deemed a tort action brought against the United States under the provisions of Title 28 and all references thereto.
Right. So in other words, unlike what Judge Feinerman thought, I mean, rather than worrying about cases that didn't decide or that, you know, implicitly did, if there's a textual argument you can make that would show that the particular part of the Westfall Act that you're interested in, the thing that allows somebody to file this belated claim, is incorporated, that's what I think I need to hear about.
I don't think there's a specific section in 233 that says we are incorporating the Westfall Act.
No, it doesn't. I mean, and we know from Hui that it's a selective incorporation anyway, but why this part? You know, what is it that
Because
supports
I
you?
think, and again, I refer to 233C, my eyes are okay here, that when there is this substitution, it proceeds as though it is brought under the provision of Title 28 and all references thereto. And that's why I think, Your Honor, the point of this court down through the years always acting as though, even in dicta, that the Westfall Act does apply, it's because that just seems to be the normal and logical conclusion.
What
That's
do
why
we
each
do
time
with the language in the Westfall Act itself, though, that says whenever an action or proceeding in which the United States is substituted as the party defendant under this section, how do we deal with that?
I think you deal with it in the fact that the section I'm referring to consumes that as well. It consumes that particular section. It incorporates.
So you're saying that by 233 sends you to that section and then thus makes the suit against the United States functionally a Westfall Act
Yes.
action?
Yeah, and it only makes sense because the whole point of the Westfall Act is to give immunity to people that are doing work for the government. That's the whole point of having this Westfall Act.
But don't you have some awkwardness in terms of like the timing? Because Section 233 comes about at a different time, and Congress enacts especially 233L after the Westfall Act. And why would you even need some of these provisions if they aren't supposed to be different?
I don't think necessarily they were needed. I think, the fact of the matter is that's why nothing changed once the Westfall Act was applied, Westfall Act was passed, it ends up because also including Section 233. And that is why I think so many courts have said that. And that's why, again, I go back to I cut Your Honors off, that the three cases, for instance, that the government says that we cite where it's dicta, yeah, it's dicta because when you read Westfall, when you read 233, that is the obvious conclusion that you draw.
But aren't we reading out under this subsection under your argument? Because the United States wasn't substituted under Section 2679.
Oh, I think
it was substituted through the removal in Section 233, which the Supreme Court said in Hugh is self-effectuating for the substitution.
Right, but there was a substitution, and if you look at each one of the cases, the three cases, they cite, I'm not sure if all of them cite 233. I think, I'm looking at one, and I believe Arroyo may have cited just 2679, and it was a 233 case, if I have my, no, that would be Blanche, I think. That even though it was a deemed case, the court cited Arroyo and 2679. I think it doesn't matter what they cite. What's important is why was it removed? And was it removed because of some entity that was deemed to be a federal employee, or was it removed because it was in fact an actual federal employee? So regardless of whether they use the numbers 233 or regardless of whether they use 2679, the removal has to relate to either 233 or 2679. And yes, sir.
Yeah, I'm thinking of the question because I'm concerned about it too, as was the district court. what we do with this, under this subsection. And I think unless you can make the argument that 233 makes that removal somehow dependent on the Westfall Act, this subsection, if you will, then you have the possibility that Congress just wanted a different regime for public health cases. They tend to be malpractice cases, right, and that sort of thing. And it might be frustrating that it's a different regime, but if Congress wanted a different regime, it can have one, right?
They certainly can do that, and I think, Your Honor, respectfully, that's a leap to assume that might have been some underlying reason. What seems
or just overlooked it, but that doesn't help you either.
Well, or felt that it was in there by the fact that 233 incorporates the Westfall Act, but that everything that's in the other statute.
What language in 233 specifically do you think incorporates the Westfall Act?
I'm looking at 233C, Your Honor, where it says that we're talks about upon certification by the Attorney General, and talks about the
deemed a tort action brought against the United States under the provisions of Title 28 and all references thereto.
Right, that's what I'm looking at.
That's if you have something, I think that is the language, because it's the only part of Title 28 that would be relevant here.
Yes,
but that doesn't help you out with the substitution piece, because the Westfall Act, under this subsection, the substitution is what is tied to that. And who or Hugh or Hui, the Supreme Court case, has said that under Section 233, that the substitution is self-effectuating, not that it is dependent upon 2679.
Yeah, but I think that's getting just too much minutia into it, or.
But if you're looking at it from the text, we need
and
that
I think
hook, and we can't read out that part.
And I think the text, just by saying that it is incorporating it, that is enough. And again, and I cite, I mentioned the fact that is what this court has always assumed, and I think the court has always assumed it, and that's what it's told lawyers it applies. Anyone reading those cases would assume it applies.
You're into your rebuttal, just so you know. You're well into it.
Thank you, Judge. I say, what I was going to finish up by saying is everyone assumed that it applies. And that is because that is the logical reading. We can get into it deep and try to analyze it, but the fact of the matter is the reason every court in this district, in this circuit, has assumed it applies just by stating it and telling lawyers, if you're reading the opinions, that it applies, is because that is how they read the statute. That is an obvious impression you would get from reading this statute.
Counsel, if I could just ask one question. I know there's a time thing, but Section 233 has its own tolling provision, right? And so with regard to exhaustion, there's so many subsections, but the tolling of statute of limitations, the time limit for tolling for filing a claim under this subsection shall be tolled during the pendency of a request for benefits compensation, basically during exhaustion. And so if under your reading it's incorporating the savings provision in the Westfall statute, which kind of encompasses the same area, why have duplicative tolling provisions?
Well, the two statutes, because they have to be different in the fact that, remember, in the 233 situation, a person is not automatically considered a federal employee. So there is a lot of, there's other things that have to be done, so they can't be exactly the same. They have to be different. And I think that's why there's differences in them. Thank you, Your Honor.
Thank you. Good morning.
Good morning. May it please the court. Notes, sir. Trying to lunge off the podium here. Okay. May it please the court. I'm Dana Kersvang for the United States. I'd like to start with this question of 233C and whether that incorporates the Westfall Act. It doesn't. 233.
Well, it sort of sends you to the Westfall Act, though. It's the remedy under Title 28.
So
they're not unrelated, you would agree.
So they're related, but what 233C tells us is that it proceeds as a suit against the United States. And the Westfall Act, those substitution provisions are for suits against employees of the United States. They become suits against the United States, and that substitution provision in 2679, but they're not suits against the United States at the time that the 2679D, that substitution, takes place, right? That is cases against an employee of the government while acting within the scope of his office or employment.
Well,
so,
that same transformation happens on both sides, on the Westfall Act side and on this other side, because ultimately what you get under the Westfall Act is a remedy against the United States. You know, and there are certain steps, and actually whether the steps are followed depends a little bit on whether the case begins in a federal court or whether the case begins in a state court, because the Westfall Act does cover that. In the case of, in the event, in subpart D3, we're talking about removals, where the Attorney General can remove this, and then there's a remand provision if it turns out that was wrong. So the remand is a little bit different. I mean, they're like little tweaky differences, but in terms of the way to harmonize these two laws, one question that I've asked myself is whether the extension of time for the person who makes the mistake that Ms. Evans made is a remedial provision of the law or whether it is not, because it seems that the Supreme Court was concerned about that in the Hui case, where they say, you know, you have to pay attention to the Bivens provisions that differ between the two statutes. So there are provisions that differ between the two statutes, whether you're going to have a Bivens remedy or not being a big one. The language is actually different. But whether this language is different is, I think, a more difficult question.
So I don't think so, Your Honor. As you said, these are two separate paths, separate schemes to getting to a suit against the United States. And under the 233 scheme, you have removal and substitution under 233, right, which sets out, as the Supreme Court said in Hui, 233C gives you a path to that. Congress, of course, amended 233 both to add the Health Centers Act, health centers, right, and put them there and not in Westfall. And then later they made additional changes to 230, they brought in 233L, which has some additional provisions about removal and substitution. And again, they put that there in the Health Centers Act. So we see this separate scheme that governs removal and substitution.
Why aren't they just making it clear which parts of the Westfall Act are unique to these suits against federal employees, such as the Bivens provision, and which parts are the same on both sides, regular employees and deemed employees? I mean, one way of accomplishing that goal would just be to repeat in 233 the parts that you want there, or incorporate by reference Westfall Act provisions.
So I think it actually does make it clear, because Westfall says cases where the removal and substitution happens under this section, right? That's Westfall D5. And then the Public Health Service Act has its own removal and substitution provisions. They don't happen under Westfall.
But do we know that's what it means? That's putting a lot of, it's like putting a lot of weight on a comma or something, under this section. In other words, it's not a 1441 removal. It's not, a 1442 removal. It's a removal under this special statutory scheme. And 233 is part of that special statutory scheme because of the references.
233 incorporates the FTCA, right? The remedy provisions in the FTCA. I don't see anything in 233, which 233A incorporates the remedy provisions of the FTCA. 233 C makes this a suit against the United States under those provisions. 233G, every time they talk about the Public Health Service Act, every time they talk about health centers, they say they're deemed employees for purposes of this section, meaning the Public Health Service Act, right? They don't make them employees for purposes of the entire FTCA.
Well, sure, they're not employees for the federal retirement system, you know, or all sorts of other things. But that doesn't tell us whether, for the remedial purposes you're talking about, part of that remedy is the time within which you can bring a lawsuit. That's fundamentally what we're talking about here. Where does the administrative exhaustion, you know, the presentation to the relevant agency fit into the system? And is that part of the remedy that carries over to the deemed employees?
So if the ability to bring a suit, a Bivens suit, wasn't part of the remedy, then I don't see how these time provisions,
Well, because there's express language in the Westfall Act that says you can bring a constitutional claim notwithstanding this structure, and there is no such language in 233, and the court decides that that is, you know, a conscious decision. There's no linkage of the two.
Right.
And it looks at the word any, it ties it to language in 233.
Yeah, and going back to the language of 233, we have every time Congress said that these health centers would be deemed employees, it said for purposes of this section, which is 233, it's not the Westfall Act. Even if in some circumstances Westfall could apply, right here it doesn't apply as both a legal matter and as a factual matter, because the removal and substitution didn't happen under 2609 under the Westfall Act. It happened under 233. But I don't think statutes of limitations are normally treated as the remedy, right? That remedy language in Hui doesn't I wouldn't think bring in statutes of limitations.
Now, this whole argument you're presenting is something the government has come to only recently.
Yes, Your Honor, many mistakes have been made in this area.
Mistakes or changes of policy, changes of interpretation. You can call it a mistake, but that's kind of a conclusory term. As Mr. Spivak is pointing out, Arroyo Blanche, maybe that was dicta. It wasn't until 2021 that we see the government adopting the position that you're arguing in the PW by Woodson case.
Your Honor, of course people make mistakes, and this is a technical area. It's easy to look at 233 and say these health centers are deemed employees of the United States.
And that's what Mr. Spivak is arguing, the common sense reading of the language as it stands, without any fancy resort to legislative history or anything else of the sort, reconciles these two statutes in the way that he's suggesting, and the way the government thought they could be reconciled up until 2 years ago.
But Your Honor, that reads the clause for purposes of this section, which is over and over in 233G, every time they talk about health centers, it reads that out of the statute. It also reads out the Westfall Act's provision where removal and substitution happen under this subsection.
I mean, it does or it doesn't, depending on what you think the cross-references to the other statutory scheme are. I'm not saying you can't read it your way, but I'm questioning whether that's compatible with the remedial purpose of this particular part of the Westfall Act. It's not the Westfall Act in gross that's being, we know that from the Hui case. It's this particular part, is that part of the remedial structure?
So it's not the FTCA in gross. If you just look at the Westfall Act D provisions, right, Westfall Act has a scheme for removal and substitution. It has steps for review for the defendant employee. It has a provision that these cases can't be remanded to state court, even if the district court ultimately determines that the United States shouldn't be a party. Those things aren't present in 233. 233 has different substitution and removal provisions. Right. Congress could have put this in Westfall, right? They did that 4 years earlier. They passed Westfall. When it came time to pass the Public Health Service Act, they put it, to add health centers, They put them in the Public Health Service Act. They didn't make changes to Westfall, and they said over and over that they were only being treated as employees for purposes of this section of the Public Health Service Act.
Right, and I suggested one completely neutral reason why they might have done that. You know, you're not really a federal employee. You don't have to sign up for the federal retirement system. You're not under, you know, the federal, you know, insurance program. You know, there are all kinds of things that come along with being a federal employee. And so it's saying none of those things are happening. You know, we're just talking about where do you bring lawsuits.
Yes, Your Honor, and then 233 has its own process for removal and substitution. Congress, you know, could have put these health centers into Westfall without making people federal employees, but they didn't. And you see in the legislative history this concern in the legislative history of Westfall, right, this concern of what is going to happen to the plaintiffs. You don't see that in the legislative history of the Public Health Service Act. The Public Health Service Act just creates this remedy, makes the remedy against the United States exclusive, and uses the removal of and substitution provisions in the Public Health Service Act, which predated Westfall and continue after Westfall. It's just a different regime for removal and substitution that has some significant differences. So that really gets us with this difference in language and the fact that they're only health centers are only treated as government employees for purposes of Section 233, and then C gets you to a suit against the United States, but not a government employee. If there are no further questions, I'll reserve the remainder of my time.
Thank you. Mr. Spivak, we'll give you a minute.
Thank you, Judge. I actually probably take a little less because, well, you know, this is what I hear on this. We made a mistake. You know, we read it this way. The courts have read it this way, that the Westfall Act, these provisions do apply on deemed employees. And when the government didn't differentiate it, we made a mistake. It wasn't a mistake. It was a natural, normal reading of the intent of the statute, and that is why the courts always, this court just assumed, albeit in dicta, that it applies. And so we're asking that it be reversed, the judgment. Thank you, Your Honor.
Thank you. The court will take the case under advisement. Thanks to both counsel. Next case up this morning is United States versus Underwood, appeal number 23-1303. Mr. Hillis, whenever you're ready.
May it please the court, counsel. My name is Daniel Hillis. I'm with the Federal Public Defender's Office. I represent Henry Underwood, and he raises 2 points for the court's consideration today. The first is a challenge to the Feretta colloquy, which we believe was defective in many regards. And then the second concern that we have is the district court's decision to hold my client in contempt of court, which resulted in 6-month consecutive prison sentence. I believe there's error in that as well. I'll begin with the Feretta issue. And in the Feretta issue, we begin with the district court, magistrate judge, who was very quick to allow my client the vice of representing himself. These things never go well for the clients. We wish that courts would not bend over backwards to allow people their Sixth Amendment rights when they also have the ability to deny the request under the appropriate circumstances and say, you can't represent yourself.
I think you have talked to the Supreme Court about that, given the case law from what they have said.
Your Honor, I would say that the Supreme Court has set out what the parameters are, but it's up to the district courts to make the inquiries and the findings. And here we have a magistrate judge who initially was ready to get right off the bench and say you can represent yourself, and was only at the behest of the government to say, please make findings, that we even have the findings that we have here. And those are defective in many regards.
But the findings are not supposed to tell us whether the person's going to do a great job, because as you said, you could almost write those findings in advance. The answer is no, they're not going to. The finding is, are you like mentally capable of saying, I want to represent myself, I don't want a lawyer? And it wasn't the longest, but you know, as you say, the government did remind the magistrate judge that he needed to go through this. He says several times, I think you're making a mistake, you know, this person is a terrific lawyer, whatever. I don't see where this record is so one-sided that we have to say that the ultimate conclusion was wrong.
Well, the prior case in the day talked about the conclusory statements of a judge. And so we're supposed to be making determinations based on what the information is presented from the defendant in response to the judge's questions. The answers here were tailored to the questions asked. They didn't go into the complexities of the case, like Erskine says from the Ninth Circuit that you should do to inform a person about, do you know how to make an opening statement? Do you know how to make a closing statement? Cross-examine witnesses, et
We've
cetera.
never said, though, that you have to go into that kind of detail. And one of the
could
points
today.
you've argued from the Ninth Circuit case is that the court didn't advise him of possible defenses. Well, that's certainly not a court's role to give legal advice like that.
That was from Van Molte, which is the Supreme Court case. So we recognize that it was in the concurrence, I believe. But in any event, it is a subject that courts have now historically incorporated, and it's part of making sure that somebody is making a knowing and voluntary decision. So I think that it should be included, and if this court has not, up until now, adopted what the scrutiny is, say, that the Ninth Circuit uses from Erskine, or that the concurrence says in Van Molte to say, please advise, and I think the Tenth Circuit has also adopted that as a practice, that you should inform somebody of a defense.
How could you possibly inform a defendant of defenses as a district court judge when you have no idea what those potential defenses might be, and certainly at the time you're doing a Feretta inquiry?
Not hard here. We have a 5-letter word. It begins with a B and ends in an N. We say Bruin. So we would have defense attorneys who would be
So you're saying you
ineffective.
advise them of some of the defenses and not all of them? And then that's going to
Pertinent ones.
cause another issue. Well, the district court only told me I had this defense and not another defense.
Pertinent ones, Judge.
But again, how is a district court in the position to advise a defendant of potential defenses in a criminal trial when the district court hasn't dug into the discovery? The district court doesn't know what the witnesses are going to say at that point. You're putting a burden on the district courts that it seems something beyond what they should be required to do at that point.
Judge, I would say that it's not much of a burden to say you may have available defenses. They could include duress. They could include a Bruin Second Amendment type defense. Those are things that are easily mentioned, take a couple of seconds. I don't know how long it just took me, but district court could easily include those things. It's not very burdensome. It would be practical.
Why isn't that giving legal advice?
It's not. Have you considered or be aware that you can raise these things? It's no more legal advice, I'd say, than are you aware of the federal rules of civil criminal procedure? And you'll need to follow those, and you will have to follow the court's rules about issuing subpoenas and things. I don't think it requires much legal advice. We're just touching on areas that should be relevant for knowing and voluntary determination for the waiver of an important right.
Counsel, the issue, though, is another issue is that the more the district court kind of piles on, right, the more the district court is susceptible to an appeal saying that, the district court discouraged me from exercising my right to counsel, right, or exercising my right to proceed pro se, right? And you're saying that that's perhaps the district court's role. I'm not, and that might be your view. I'm not really sure what the Supreme Court would say on that, but I think that as we've recognized, the district courts they have to walk a very thin line, right? And so the more you kind of raise saying, oh, have you thought about this? And have you thought about this? And at some point, it's too much. And so then where does the touching on issues become too much?
Well, I can say here it's too little. So we don't have a circumstance where under a record of this type, I think anybody would come up and complain that the district court, and we are sometimes looking at this from the tail end, right? I would not complain looking at this case if my client had a lawyer throughout, Judge Lee. So I'm not asking that too much be done. I'm asking that enough be done. And here, when the judge did not cover, and I'm just going to rattle through these quickly so I can move to the next issue, age, the charges, the education, the penalty, education of my client, the penalties that my client faced, the context. He did not ever ask my client why he wanted a new lawyer. He said he assumed that he knows the reasons why. That was not covered then. Defenses, knowledge of the rules was done cursorily, right? Rules of criminal procedure. My client's experience was not especially touched upon, the complexities of the case, and I'll conclude with this. The government's use, and it's supported by case law, to have a backward-looking view of, and then the person went after the FREDA colloquy and did these following things, and that must inform that they had knowledge and this was voluntary because look how well they did or what they did after the FREDA colloquy was over. To me, that is badly flawed. It's illogical that cases would ever do this, to look to say whether a person made a knowing and voluntary decision based on the information that was present in front of the judge at the moment the inquiry is done, versus, and now we'll look with the benefit of hindsight and take in all the things a person did well and say that that girds our decision to find there was a knowing and voluntary decision that happened months earlier, days earlier, weeks earlier. That doesn't make any sense.
Doesn't our case law permit that?
I'm saying it doesn't make any sense.
So you're asking us to overrule
I would ask the
those
court
cases?
to consider the wisdom of that. Finally,
It's a delicate way to put it, Mr. Hillis.
Judge, I'm not often called delicate, but thank you. As for the second issue, the district court wrongly held Mr. Underwood in contempt when he refused, under cross-examination, to identify the person who was with him when he confronted his adversary. This, we think we have stronger grounds than our FREDA issue. And I'll
But
be
he
candid
kept
about
saying that the only reason he was invoking his Fifth Amendment rights was because he didn't want to incriminate another person. He never says, can I talk to my standby counsel, even though he had been doing so throughout the trial. And the district judge isn't wrong to say that worrying about somebody else's incrimination isn't part of your Fifth Amendment right. You can think of, you're a good lawyer, you can think of all sorts of things maybe with the other pending charges or what have you, but it's hard for me to blame the district judge for taking him at his word.
A couple of quick answers to that. First of all, under Hoffman, he shouldn't have had to explain, because he's now having to explain things at his peril to say, I'm going to tell this information, here's what it is, and then the district court can make the decision to understand what the strategy is. And it may alert the government about things that are going to be useful for the government to prosecute him under the 1958 8A charge. Also, Yee versus City of Escondido, we would have, of course, you may have heard me say this before, I'll say it again, you can waive a claim. You do not waive an argument under Yee versus City of Escondido. So my client said enough when he said, I have a Fifth Amendment right. The judge should have been aware, and the case law says under Malloy from the Supreme Court, the judge is not divorced from the proceedings. This judge is presiding over the 1958A and the 922G1. She should know this is a hazardous course that I'm steering now. He's already said Fifth Amendment, that should be enough. Now I'm making an inquiry, an explanation rather, and that violates Hoffman in our opinion. And then when he does lay out what his reasons are, he does not do a good job. But I don't see ever where she said, take a minute and consult your lawyer. That takes us into Morton, into Brummett, in the cases from the Third, the Fifth Circuit, wherever else you'd like to look, to say that as a matter of Fifth Amendment protections and Sixth Amendment protections, due process and your right to counsel, the judge should be tapping the brakes. District courts are fearsome vehicles when they want to be, and there was not a lot of consideration shown from my client here. The brakes should have been tapped. There should have been a moment where somebody pressed pause and said explicitly on the record, maybe take a minute and consult your lawyer to get a chance like you have in other cases to purge the taint, things like this. This wasn't done. This should have been done.
Okay, thank you, Mr. Hillis. Mr. Howard?
Good morning, Your Honors, and may it please the Court. David Holler on behalf of the United States. Underwood knowingly and intelligently waived his right to counsel, and the District Court did not err in holding him in contempt, and this Court should therefore affirm. I believe Mr. Hillis has talked a lot about best practices, perhaps, but I don't believe he's demonstrated any reversible error on this record by the District Court.
Mr. Howard, as you, I'm sure, are aware, the bench book that's given to judges has a detailed list of questions to ask in a FREDA inquiry, and that was not followed here.
It wasn't, and this Court said in Hill it doesn't have to be. again, I guess just to echo what I just said, we can talk a lot about best practices, and I certainly think it's always advisable, and we wouldn't even be here if Judge Cherry had read the bench book. But this court has said over and over again that you don't have to read the bench book, and the court isn't going to reverse on that basis. Instead, it's going to look at the 4 factors, and I really think the first factor, this inquiry was complete enough. The point of Ferretta says the purpose of the Ferretta inquiry is, does he understand the disadvantages of going pro se? And that was fully covered here. All of the things that need to be covered were covered. You are going to be on your own. You might have issues come up, as we see through all the contempt proceedings later on, that you're not going to be able to deal with. You are going to have to figure out how to do all of these things on your own. You may have defenses that you aren't aware of. But this court has never suggested that the purpose of a Ferretta inquiry is to sort of give the defendant a roadmap of like, hey, you might have a Bruin argument. You might want to move to dismiss the indictment. You might want to raise 404B issues. I mean, none of that's the role of the lawyer, which they're waiving, and maybe if they go to their standby counsel can help them with that. But that's not the role of the magistrate. It's never been the role of the magistrate.
What about the failure to explicitly inform the defendant of the maximum potential penalties?
So this court has said, I believe in Johnson and Todd, that you can look back and see that the penalties were accurately stated at prior proceedings. So he was accurately informed in the initial proceedings. There was a document filed. The district court required a notice of penalties to be filed. Mr. Underwood, as the counsel of record, had access to the entire docket. If he wanted it, he could have reviewed those penalties at any time. And unlike the few cases that my opponent has cited where that issue has been raised, though that was raised in the context where the defendant, there was some indication in the record that the defendant didn't understand what the statutory penalties were. Here there's nothing suggesting any of that. And I want to be clear, the racketeering murder charge has nothing to do with this felon in possession charge. The racketeering murder charge, if you look at the indictment in that case, involves incidents that occurred between May and I believe July of 2018.
And going back and looking at the docket, though, this Ferretta inquiry was for both cases, correct?
It was done for both cases. Yes, he did move to withdraw. Have his lawyer move to was it the same lawyer in both cases, and he did move to withdraw in both cases, and this was done as a consolidated proceeding.
So that's why those were raised in the first place.
Right. My only point is there's no indication he misunderstood the charges. Even though the penalties weren't explicitly stated, there's no indication that he didn't understand what they were. I mean, the reference to penalties is coming in from Von Moltke, which was an instance where the defendant was pleading guilty and didn't have a lawyer present, pre all of these right to counsel cases. And so there was an important focus on that in the guilty plea context. But in general, the purpose of trying to have the defendant understand the penalties is just to understand the gravity of all this. The defendant is also, at the same time he's doing this, going pro se on a racketeering and murder charges that are very serious. There's no indication here that Mr. Underwood didn't understand the seriousness of what was going on. He had prior convictions. He had participated in a prior state court murder trial, apparently with counsel, where his counsel secured an acquittal. He knew what was going on here. He went into this with his eyes wide open, and this occurred in many months before his trial. He knew what was going on.
But when asked, do you understand the federal rules of criminal procedure, rules of evidence, and he just says yes. This is a guy with a 9th grade education, right? I mean, the judge doesn't probe that question at all. He just takes a yes, as though this guy actually does know those rules.
I mean, he managed to get subpoenas served. He managed to get witnesses present in court. So I think we normally take the defendants at their word when they're going to be a lawyer, just like we normally take lawyers at their word. And if there's, and I think that's the way the court has traditionally handled this. I'm not sure that I know that the bench book inquiry is much more probing than what's here, but I don't know that it's going into, extreme levels of detail of asking them to, well, explain to me how this rule operates, or explain to me how you understand, I don't think it's going into that level of detail. And I also think, again, even if the court thought on the first factor, okay, formal inquiry, we're a little shaky here. Well, let's look at everything else. Is there anything in his background and experience? What do we look to? Well, we've said 7th grade education's enough. This guy has like a 10th grade education. We've said any sort of prior criminal history helps. Well, he has plenty of criminal history. There's no indication that he's a sovereign citizen. There's no indication that he has any mental issues.
Not at that point. I mean, I guess later he files some pretty strange motions.
He files a lot of motions in this case. Some of them are strange. Many of them are not. This is not a sovereign citizen case by any means. And then my only other, I did want to just point out that these two cases are totally unrelated, because that sort of dovetails into the contempt issue. There's no, to the extent that it even matters, there's no way that anything he says here is going to have any impact on his other case, because they aren't related in any way, shape, or form.
Mr. Haller, with regard to the contempt proceeding, it is a little bit concerning that the judge didn't take the time to inform Mr. Underwood of perhaps it'd be advisable for him to seek counsel or have counsel with regard to the criminal contempt proceeding, because it could increase his eventual sentence. If this were a pro se proceeding in a civil context, we would certainly require, I think, the judge, or it would be, for me, it would be very troubling for a judge not to inform the pro se person in a criminal contempt proceeding that they have a Fifth Amendment right and that they have right to counsel and all of these constitutional rights. Why doesn't the same apply here?
So this is a summary proceeding. It's under Rule 42B, and so the...
But it's a summary criminal proceeding that could result in a longer criminal sentence, right?
It can result in a longer criminal sentence, and I guess de facto here it did result in a longer criminal sentence. But the point is that the Wilson, Pounders, all these Supreme Court cases essentially say this is part of the court's inherent powers, and that there is no due process right. There's no Sixth Amendment right to counsel in these proceedings. So any witness in the proceeding, it wouldn't have to be a pro se defendant, but any witness in the proceeding would not, there's no requirement that counsel be appointed for, even if there was even if a witness had called, if Seneca James had gotten on the stand and testified and then said, now I'm gonna not answer any more questions because I don't want to be a snitch. If the court had ordered that witness to answer and he had refused, the court could proceed summarily and say, I'm holding you in criminal contempt. And I think you could do that even in a civil case. So what courts have said, and I think in Brummett in some of these cases, the courts say, oh, we think it's best practices, we think it's a good idea that you did that, what another district court judge might have done. There is no due process requirement. The other thing that I would point out here, I guess this dovetails back to the first issue, is, he is a witness, but he's his own lawyer. He's waived his rights to counsel in this case. So if there was a criminal defendant who had counsel there and the court, didn't let him consult with his counsel, that's one thing. But I think really he has told the court, I'm going to be proceeding as a lawyer here. And we know in Pounders versus Watson that attorney was not told, hey, I should be allowed to have my own counsel when you're going to sanction me as a lawyer. And I don't see any reason why that should be treated any differently here. And in terms of the Fifth Amendment issue, for all kinds of reasons, his arguments are invalid on this. And I mean, first and foremost, if the district court was wrong, the district court was just plain old wrong, and he did have a Fifth Amendment right, the way that should have been dealt with is he should have answered the question and he should have appealed and said, now there's error infecting my conviction. That's how this is always handled, right? If the district court is wrong, you don't just say, no, I'm not going to follow your order. You take the district court up on appeal, and Court of Appeals tells the district court judge that the district court judge was wrong. You don't get to decide that. Beyond that, I think the Supreme Court cases, Brown and Rogers, fully show that once he's made all of these statements, he has to testify as to the details. There's a good discussion of this in United States versus Mitchell as well, more recently. So there was no error here, and so the contempt was proper, and the Feretta colloquy was sufficient, and even if it wasn't, he did demonstrate enough to go pro se. The judgment should be affirmed. Thank you.
Thank you, Mr. Haller. Mr. Hillis? I can give you a minute.
Thank you. So when my client invoked his Fifth Amendment right against self-incrimination, it made it now for the government to meet its burden to show how the information could not possibly tend to incriminate him. The government's lawyer never did that. What the government's lawyer responded
But
was said
is that
relevancy.
the inquiry? Isn't the inquiry whether or not an answer to it was relevant to the charges he was facing?
No, I think that is not. I think that's the problem that the prosecutor made for the government here.
But you've waived it. You've waived your Fifth Amendment privilege when you take the stand and testify. And if there's an answer on question on cross-examination that is directly responsive to what you've testified to and relevant to the proceedings, you've waived it.
A couple of things. How is it relevant in the 922G prosecution to know who was with you when you possessed a gun? That information where the government said earlier it wouldn't be used in another case. The other case is a case involving co-conspirators in 1958A. It is directly helpful to the government to know who else was with you
It's
committing
directly
these offenses.
relevant when you say, this is a 922 gun charge. I was at the same place, but the gun wasn't mine. I didn't touch it. I didn't shoot it. Somebody else did, but I'm not going to tell you who that is. That's directly relevant to say who that person is.
I don't think it's relevant to the ultimate issues in the case about did you possess it. It's rather who was with you. That's not the same inquiry. And furthermore, it's on cross-examination by the government that's asking the witness this. The witness
Exactly.
is not there with the bullseye. He still has Fifth Amendment rights that he can invoke. He properly invoked them here. And we think that the government shouldn't have been allowed and didn't, when it tried to conduct the questioning, shouldn't have been allowed to, because it was obvious that my client's answers had the possibility to incriminate himself.
Okay, thank you, Mr. Hillis.
Thank you.
Case will be taken under advisement. The next case for oral argument is United States versus Kraft, appellate number 22-3015. And Ms. Kelly should be appearing remotely.
Good afternoon, Your Honors. My name is Attorney Anise Kelly, and I represent Mr. Kraft in this matter.
Good afternoon. Can you hear us okay?
I can. Can you hear me?
Yes, thank you.
Thank you. Yes, I represent Mr. Kraft in this matter, and I would, Mr. Kraft raises two issues, the drug house enhancement and the supervisory role enhancement. I would like to focus on the drug house enhancement. In its ruling, the sentencing court said there was barely enough evidence for this enhancement. Mr. Kraft argues that the court erred in this finding. In 2017, this court held in U.S. v. Contreras that use of the house must be more than incidental or collateral. Mr. Kraft argues any use was incidental or collateral.
Why, Ms. Kelly, why is that the case if there's evidence showing that Mr. Kraft and other people are sitting there at the table in the house planning what they're doing, or the house seems to be kind of a way station for the drugs. They don't keep them there for months at a time, but they're there overnight. They're there for 24 hours, and that practice of using it as a way station seems to be, at least the evidence seems to indicate, is well established. So I wouldn't say this is the most extensive use of a house I've ever seen, but it doesn't have to be exclusive. So why don't we have maybe just enough here?
A couple of points, Your Honor. There's no evidence in the record that the house was used for planning operations. And the government has distorted Mr. Schaefer's storage of the drugs at the house. And that's part of our argument. What the evidence shows, so the government has said repeatedly in its brief that Mr. Schaefer would get the drugs from Mr. Kraft and bring them back to the house every time. Government puts it at 30 times or about twice a week. There's no evidence of that. Mr. Schaefer's testimony was that it occurred, quote, many times. The government, who has the burden of proof, never clarified what many times meant. In fact, Mr. Kraft gave the drugs to Mr. Schaefer at a gas station. And in our mind, that's evidence of intent not to use the house as a drug house. And so if you focus on Mr. Kraft's behavior, he gave the drugs more often than not. Mr. Schaefer testified that he got the drugs at a gas station, except for several times he got them at the house. And once again, there's no number on several times, and several times could be as few as 3. Mr. Kraft never sold drugs at the house. No other indicia of drugs, house, or tools of the trade were found at the house. So basically, you have Mr. Kraft giving to Mr. Schaefer, quote, several times drugs at the house. But more often than not, they were at the gas station.
Well, certainly
So
the transfers are at the gas station, but I thought there was evidence in the record from which one could conclude, as I used the word way station, I mean, that there is, a brief use of the house commonly with these transactions.
That I think, as you said, it may not have been 30 times, but there was certainly testimony that he, on numerous occasions, took the drugs that he received at the gas station back to the home.
For up to 24 hours, not for a long time.
On that point, Mr. Schaefer's testimony was, quote, many times. Again, a vague term that the government, who has the burden of proof, never quantified. So again, many times.
Why wouldn't that be enough, though, if it's many? Why do we need a specific number?
So again, the district court found on this evidence that there was barely enough, but included in the district court's finding on the barely enough evidence was the source of income and the co-conspirators' activity. And it's Mr. Kraft's position that in a case like this, where there's barely enough evidence, the source of income and the co-conspirators' activity shouldn't be the main evidence, which it is in this case. And all the cases cited by the government to support the source of income or the co-conspirators' use, in all of those cases, before the court makes a finding of the use of the livelihood of the co-conspirator, they make an independent finding that the sentenced defendant independently used the house substantially for drugs. For instance, in Beecher, the court characterized it as large quantities meant for later sale. In Sanchez, the court characterized it as massive amounts at the house. In this case, we have a district court saying barely, and that barely includes the source of income and the co-conspirators' activity. So those courts did not use that as the main evidence. So Mr. Kraft is asking this court not to extend those cases to allow the source of income or co-conspirators' actions to be the preponderance of evidence that tips the scale in a case with barely enough evidence for the enhancement, even with this evidence. And as I stated earlier, the government has distorted the co-conspirators' use of the house.
Ms. Kelly, if I could ask you something. The instances where Mr. Kraft gave Mr. Schaefer the drugs at the gas station, was Mr. Schaefer still living at Mr. Kraft's house at the time?
Yes. So again, that's more indicia that he did not intend to use the house as a drug house because they were living together. He easily could have given all of the drugs, every transaction could have taken place at the house. Instead, only, quote, several did.
And my understanding from the record is that when what Mr. Kraft would do is he would go to his supplier, grab the drugs, come back to the house because Mr. Schaefer lived there, and gave it to Mr. Schaefer at the house, and then Mr. Schaefer would spend the night and then drive away and distribute it. Is that an accurate explanation or a disposition of the record?
Well, no, Your Honor. The vast majority, the record is clear, the vast majority of the transactions happened at the gas station. Mr. Schaefer testified there were times when it happened at the house, but that was certainly not the norm. The norm was the gas station, and the government never established how many actually took place at the house.
Is there any evidence that Mr. Kraft stored the drugs at the house before he gave them to Mr. Schaefer?
The opposite. The evidence established he never sold drugs from the house and he never stored drugs from the house. The district court relies on the handful of incidences where Mr. Kraft gave Mr. Schaefer the drugs at the house and the co-conspirators' activity of using the house and the source of income. And again, our position is...
Why isn't the co-conspirator evidence appropriate to rely on? If it's reasonably foreseeable to the defendant, we rely on actions of co-conspirators or hold defendants accountable for actions of co-conspirators in many other circumstances, including amount of drugs. So why wouldn't it be appropriate, as long as it's reasonably foreseeable to Mr. Kraft, to rely on the actions of the co-conspirators at the house?
Well, I would argue in this case where you're enhancing Mr. Kraft's sentence or any defendant's sentence on the use of their house as a drug house, the primary focus in all the cases, the primary focus is on the defendant's actions, and then a supplemental is the co-conspirators' actions. But in this case, the government wants to make the co-conspirator the main evidence, and Mr. Schaefer's actual use of the house, as I said, never sold, never stored, no indicia of any sort of drug use or drug transactions at the house. It's relied upon by, Mr. Schaefer and the source of income. I see my time is up.
Okay. Thank you, Ms. Kelly. Mr. Canestra? Good afternoon.
Good afternoon, Your Honors. Jeff Kinstra on behalf of the United States. The district court didn't clearly err in applying either of the enhancements here, beginning with the premises enhancement.
Is clear error the appropriate standard? I know that we apply clear error to the district court's finding of facts, but as far as the district court's determination that the facts so found, qualify for the enhancement, that is a legal determination that we review de novo, isn't it?
No, as this court explained within the last year in Viverito, the fact-specific application of a legal rule is something that this court gives deference to on appeal. So in that case, I believe it was in a child pornography case, whether it involved a certain sort of conduct being depicted in the materials, the district court found that it was. This court gave deference to that, even though the appeal involved some haggling over exactly what the standard meant. The court explained essentially that the fact-specific application of a legal rule is something that this court reviews deferentially, and so that applies equally to the district court's conclusion here that the use of the house for the drug activities was more than an incidental or collateral purpose and qualified as a primary or principal purpose. Beyond that, the factual findings that the district court made amply support that conclusion. First, as your honors have already recognized, drugs were moving through this house frequently and also in significant amounts. And perhaps to clarify some of the testimony about that, Schaefer himself testified that there were many times when he had drugs with him at the house. He said that was one of the reasons why he and the defendant would watch the security cameras together in the defendant's room, because they were concerned about the law coming. And the reason Schaefer was concerned about that was that many times he had the drugs with him at the house. The pre-sentence report puts them...
Typically only on that short-term basis, though, up to 24 hours.
That's correct. And the pre-sentence report is where the 30 occasions comes from. Schaefer himself said that on about 30 occasions,
What report? I'm sorry.
The pre-sentence
The
report,
okay.
and specifically at paragraph 36, he said that on about 30 occasions, Crafts gave him the drugs, and then he further testified at the hearing that when that occurred, he would have the drugs with him at the house until he left for Illinois to distribute them, and that, he said, was about within the day or within 24 hours that would occur.
But usually usually Kraft delivers the drugs to Schaefer at a different location, and
That's
then
correct.
Schaefer goes off to the gas station or whatever he's doing.
That's correct, but Kraft also, on occasion, delivered them at the house on at least several occasions to
But
Schaefer
does that
himself.
get you over the line from incidental to sufficient use of the house to justify the enhancement? It's a very, as the district court judge commented, it's a very thin record.
I think that the district court appropriately characterized this as a close case, and that's exactly the sort of case where it's the district court's role to resolve which side of the line it falls and where this court defers. And I think it's not only that specific fact in particular. Of course, it's the number of times the drugs are moving through the house, the amount, as the district court noted, it was up to a pound or two at a time. And when it's up to a pound or two at a time, 30 times over 4 months, that's a very large amount. It's much, the activity is more significant than this court's decision in Contreras, where it was 8 transactions, 7 of which occurred over 2 months. Here it's about twice as often and twice as long.
But they aren't sales.
It's not sales, but it's still the interaction between the house and the drugs. On top of that, Kraft would also receive proceeds there. And the district court appropriately recognizes, this court itself has recognized on multiple occasions, these activities and the proceeds they derived from them were critical to their livelihoods. They had no other jobs. They relied on these proceeds
I don't know how that
support their
ties
rent.
it to the house. I mean, the government makes the argument that they were using the proceeds in part to pay the rent or, housing costs, but that does not, to me, tie anything to the house. That's an after-the-fact thing. I mean, it's just money, and I don't think that's a relevant factor.
So the toehold still has to be the activities that take place at the house. And then the use of the reliance on proceeds for their livelihood is a way of gauging the significance of those activities and determining whether those activities are a principal or primary purpose. And that's exactly what this court has held on multiple occasions. As this court has recognized, whether the activities that occur at a house are a primary or principal purpose for maintaining the premises depends in part on the frequency and significance of the activities that occur there. And so this is it is relevant to the significance. As Edwin Sanchez, for example, noted, it found that the enhancement applied when the drug activities were significant in quantity, scope, and importance to the defendant's livelihood. So that really parallels the district court's findings here. They're significant in quantity, up to a pound or two at a time, 30 times over a few months. Significant in scope, we have deliveries occurring there, we have storage there even for brief times, we have proceeds coming through the house, and they're also significant in importance to the defendant's livelihood. This is his sole means of support is the proceeds that he derives from these activities.
What should we make of the fact that Mr. Kraft handed off the drugs to Mr. Schaefer at a gas station away from his home when I know there are a couple occasions he did it at the home, but for the majority of them, it was somewhere else, which, as Ms. Kelly pointed out, suggests he didn't want the distribution out of his house.
Right. That's perhaps an inference that the district court could have drawn. It's not what the district court did find here. And a couple things to say about that. On the one hand, I think it shows that Kraft himself is sensitive about not having the drugs in his own hands, in his own possession. It shows that he's trying to get them in his co-defendants and his distributors' hands as quick as possible, which also just kind of feeds into the manager-supervisor enhancement. I think, Judge Lee, the factual scenario outlined earlier about how Kraft went to get the drugs and just handed them off to the gas station is likely correct. The record itself doesn't establish where the defendant was obtaining the drugs from, but the fact that he's going out and picking them up and then handing them off to Schaefer at the gas station, I think reflects that he's probably picking them up from his supplier. There's no evidence that he has some other storage facility that he's keeping the drugs at. And so
but if it is a supplier, I mean, this is all we're talking about is whether this premises enhancement was appropriate for a sentence. We're not talking about his guilt. We're not talking about all sorts of other things. And so, as Judge St. Eve was saying, if he's going out of his way to make sure that he's not using the house, then why is the premises enhancement appropriate?
Well, because he is using the house. First, on occasion, making deliveries himself. Do you need me to?
Let's hold the clock for just a second. We lost our monitor here. Ms. Kelly is still present. On the other monitor, ours just turned off.
It did time out. It said that it was going to.
She was
I am
press it.
here. For some reason, it muted me.
There we go.
Oh, there you are.
Thank you.
You're back.
Okay.
We can see you now.
Sorry about that.
Sure.
Thank
so,
you.
so the defendant is still using the house. He is on occasion making deliveries there, and he knows that his co-conspirator is in fact using the house for this purpose. He knows that when he's giving them, his co-conspirator, the drugs, that they're home together. They're watching the security cameras in part to see if the drugs are coming, or if the law is coming, in part because Schaefer had the drugs with him, and he knows that when Schaefer's there in the house with him, he's not on his way to Illinois to sell the drugs. So these are activities that Schaefer is engaging in the house that further the defendant's drug distribution and that reflect the defendant's purpose for maintaining this premises. I think the Sixth Circuit really squarely addressed that in an opinion about a month or two ago in Terry, where it said that a court may consider the co-conspirator's conduct in applying this enhancement, and that the co-conspirator's use of the defendant's premises is something that a court can count towards the activities that reflect the reason for which the defendant is maintaining the premises. And really that's the case here. It is the defendant who's maintaining the premises. It is the defendant's purpose to facilitate or to use it for the purpose of drug distribution. And this is one of the ways in which he uses the house for that purpose, by allowing his co-conspirator to move into the house with him and then have the drugs with him there before he leaves for Illinois. We haven't discussed the manager-supervisor enhancement this morning. I'm happy to answer any of your questions on that.
Does it matter that Mr. Kraft gave Mr. Schaefer the drugs before Mr. Schaefer stored it in the house temporarily and left? I mean, Kraft could have, if he wanted, right, he could have given it to Schaefer right before he left for his customers. Right, it seems like one would seem to lean towards indicating that Kraft was using his house, wanted intentionally to use his house to store it, whereas the other, that Schaefer living there was just kind of more incidental.
I think along those lines, if Kraft really wanted to distance his house from the drugs, he could have picked up the supply and met Schaefer at a gas station while Schaefer was on his way out of town. But that's not what he did. He picked up the drugs, would give them to Schaefer either at the gas station or at the house on occasion, and then the drugs would be at the house until Schaefer would leave within the next month. So essentially our position is that this was, as the district court recognized, a close call, and that's exactly the sort of call for a district court to make, and we ask this court to affirm that decision.
Thank you.
Thank you.
Ms. Kelly, we will give you a minute.
Thank you. 3 quick points. Your Honor is correct that the standard of review is de novo for the application of the guidelines, and we would ask that the court not extend the co-conspirator to this thin of a record on Mr. Kraft's actual use of the house. The second thing is the court dismissed out of hand. It called it a bridge too far, this issue of the security cameras. It played, the court rejected, it played no bearing in his ruling that the house was used for the enhancement. And the third thing is there's no evidence that Mr. Kraft knew that Mr. Schaefer was bringing the drugs back to the house after he gave them to him intentionally at the gas station. Thank you, Your Honors.
Thank you, Ms. Kelly. The court will take the case under advisement, and Ms. Kelly, you were appointed to represent Mr. Kraft in this case. The court thanks you for your time and strong advocacy you've put in on behalf of Mr. Kraft.
Thank you.
The final case for oral argument today is United States versus Houston, appeal number 23-1057. And Mr. Pennington will be appearing remotely. Good afternoon, Mr. Pennington. Can you hear us okay?
I can, Your Honor. My apologies. Having a little bit of a tech issue there.
No, that's okay. Whenever you're ready to proceed, please go.
Thank you, Your Honor. Chad Pennington on behalf of the appellant in this matter, Mr. David Houston. Mr. Houston respectfully requests that this court reverse the district court's determination that the good faith exception to the exclusionary rule applies and remand this matter for a determination of whether the warrant was supported by probable cause. Your Honor, at the outset, I would like to emphasize that this is not a case where the application of the good faith exception would further the prophylactic function of the Fourth Amendment. I think, moreover, in addition, this is not a case where the application of the good faith exception is consistent with the exclusionary rule and its primary policy justification, which is grounded in the deterrence of law enforcement investigations and deterrence specifically of Fourth Amendment violations in those law enforcement investigations. I think we can group the misrepresentations, the omissions, and the breach of department policies as regards to the Franks violation in basically just that, three basic fundamental groupings. By our count, you have at least 5 misrepresentations or falsities, and those were material to the finding, they would be material to the finding of whether there was probable cause. The district court found up to 12 12 omissions. Didn't make the finding of probable cause, but it found up to 12 omissions. There's also the breach of department policy. And so when you combine the three of those combined, that is probative of the subjective frame of mind of the affiant in this case, Officer Ross.
Well, what impact should it have that many of those omitted facts really strengthened probable cause rather than took away from it?
Your Honor, I think that when we can kind of begin with the misrepresentations. And when you look at, there's 5 misrepresentations.
So are you saying we shouldn't assess the potential helpful impact of the omissions without looking at the misrepresentations first?
Your Honor, I think that you would want to look at, the court would want to look at the omissions, the misrepresentations in tandem. And but using the misrepresentations as a basis to say what is the effect on the probable cause finding here. And when you look at the 5 misrepresentations, specifically I'll start with paragraph Q, which states that there's a person observed leaving the residence. Well, the officer on testimony indicated that just wasn't observed. So when you look at that particular information submitted in the affidavit, it has a material effect on the subsequent portions of the warrant. Paragraphs R, S, and T, they're all premised on someone being seen coming from that residence, being viewed, and it gives the impression that the person was seen being viewed from that specific residence and then having subsequently been pulled over and having narcotics found in the car. But that wasn't true. Nobody was seen coming from the actual residence. So it gives a false impression. I think when you look at the misrepresentations and the omissions, Your Honor, I don't think you exclude omissions that potentially would be helpful to the government's case here. But when you look at the effect of the misrepresentations, first and foremost, that has a material bearing on the finding of probable cause in a way that the omissions just don't equal. I mean, paragraphs Q through T are predicated entirely on a person being observed exiting that particular residence, being followed, committing a traffic violation.
How material is that, though, given that there were only 2 entrances to the facility, and they know he didn't go in one, they know he went in the building, and the only location the other entry led to was to the defendant's apartment?
Your Honor, I think it is very material. And the reason it's very material is because if you don't know which particular residence he entered, well, then you really can't make an inference as to whether the narcotics could have been found in Mr. Houston's apartment.
But can't it be inferred that he entered Mr. Houston's apartment because he wasn't observed going in the other door which led elsewhere? There was only one other way for him to get in.
Your Honor, I think that the inference could be made, sure, but I think that when we look at whether there's probable cause and whether there's a fair probability that the narcotics were found in Mr. Houston's residence, that didn't happen. So that undercuts the finding of whether those drugs, there's a fair probability that they're animating for Mr. Houston's residence. That just simply didn't happen. We didn't see the person exit from there.
So I want to go back to the tipster, though, because you made some point about what in the affidavit gives the impression that he's anonymous. He isn't. As it turns out, they sat around with him for 15 minutes, and he takes them and he shows them the place, and they eventually decide to pay him. But that struck me as one of those facts that it would only have helped the affidavit to have said this was actually a person known to us, and there's plenty of law that says that. So I'm having trouble seeing the materiality, and once you get all that information from the tipster about how much drugs he was able to buy and what was in the apartment, a lot of the rest of this is cumulative, and the district court makes the factual finding that maybe there's exaggeration, or maybe there's there are slight misstatements, but that this was not done in a way that was designed to bolster probable cause where it wasn't there.
Your Honor, I would say that with respect to what was omitted as to the tipster, it does read as if it's an anonymous tipster, but it's not. But there's also the omissions that go to this particular informant's credibility. It's not just that he's anonymous or not anonymous. It's the information that is omitted goes directly to the information and whether it's a credible source or not.
So he's got a bigger criminal record than people thought, but they thought there was something. And the state judge takes that much into account when he issues the warrant. I just don't see why it makes the affidavit that much worse off by failing to say that we actually know who this tipster is. An anonymous source could be anything.
Your Honor, I think it would also be the type of criminal history. It's not just the omission of the criminal history in the abstract, it's the kind of criminal history. There's criminal history that relates to domestic battery. There's criminal history that relates to a crime of moral turpitude, theft.
But
so it's
he
not
didn't
just
know that before he submitted the affidavit, did he? The detective, I think the district court made the determination that the detective did not know the extent of his criminal history when he completed the affidavit. Now, maybe we could certainly talk about whether or not he should have done it beforehand, but for a Franks violation, that's an intentional or reckless disregard. And if he didn't know the information, how do you make that finding?
Your Honor, I think the testimony established that he had the capacity to find out had he just did a basic search. It's telling that they know.
But he didn't know. I think the judge made the specific finding. He did not know here.
That is correct, Your Honor. I think what it goes to, again, is the subjective state of mind of the affiant here and the circumstantial evidence that he's acting recklessly and he's not comporting with departmental rules in seeking in the affidavit. And I would, Judge St. Eve, one point regarding a question you had posed earlier is I don't think the district court comes out and makes a finding as to the implication of all the omissions. It says that many of the omissions can be explained away, but not all of them. And I think that's important here on whether the district court abused its discretion, because it's really not working through all of the omissions and their implication on the finding of whether there's a Franks violation. If I may, Your Honor, may I reserve the remainder of my time for
Yes,
rebuttal?
of course. Mr. Whalen?
May it please the court. Good afternoon, Your Honors. Nathaniel Whalen here on behalf of the United States. I want to pick up on what the defendant just said. This isn't a case about abuse of discretion. This is a clear error standard of review. Excuse me. And those words weren't uttered at any point during the argument. They're barely touched upon the brief. And this is a different procedural posture than the Franks hearings usually come up to this court. Usually it's a question of whether there should be a hearing or not. Excuse me, Your Honors.
Want some water?
I think I'm okay. I'll push through it.
Okay.
This is a case where Judge Brady sat and she had a hearing. She observed the testimony of Officer Smith. She observed the testimony of Officer Ross. She heard the arguments that are reiterated again on appeal, and she made a credibility determination that they were not acting recklessly or with intentional disregard for, they weren't trying to pull the rug out from under the issuing magistrate's eyes. Judge St. Eve, Williams, this court's case in Williams goes directly to Your Honor's question about how much weight we give the omitted information that would have supported probable cause, and that's what Judge Brady found. She found that there were a lot of things that were omitted that would have supported probable cause, and Your Honors have hit upon them. That doesn't bolster the probable cause analysis because we're confined to the four corners of the affidavit. What it does show, though, It supports the inference that these officers weren't tunnel visioned and they weren't going for probable cause at all costs. They weren't trying to commit a ploy upon the issuing magistrate.
They weren't just leaving the bad stuff out.
Correct, Your Honors. They were leaving a lot of stuff out. And, that's frustrating as we sit here today that it wasn't included in the affidavit for sure. But it does go to support Judge Brady's credibility determination that they weren't acting with reckless disregard or intentional misconduct.
But there are inconsistencies that the judge kind of doesn't really quite address, right? And what I'm referring to is this whole thing about the green Mini Cooper, right? And the fact that the tipster tells Detective Ross that the Mini Cooper is one of the cars that Mr. Houston owns, doesn't say anything about driving it. They never see Mr. Houston in the car, driving the car. And yet, in the affidavit, Officer Ross says detectives were told that Houston has multiple vehicles, but that he drives a green Mini Cooper. That was never stated in the. That's never does not appear in the transcript. And then in P, they said when we then returned to the area and while conducting surveillance, observed the green Mini Cooper that Houston is believed to be driving arrive. To me, that wording is like almost too clever by half, right? It's like, we can't say he drove it because we didn't see him drive it, right? But we can say that it's a car we think he drives and it arrives, so therefore he must be there. That in conjunction with the allegations regarding Mr. Gregory coming in and out and the admission that Mr. Gregory is a known drug dealer himself, and so it's not surprising they find drugs in his truck. What troubles me about this affidavit is that it really looks like it's quite slanted in trying to convey the impression that we know that Mr. Houston's there because we see the green Mini Cooper, which he's believed to be driving, even though no one told us that. And then we have Mr. Gregory, who, by the way, is a known drug dealer, but we don't tell you that. And he has drugs after he visited there. That, at least to me, raises some yellow, if not red flags.
And maybe drugs before he visited there. We
Right.
have no idea what was in the car, what was in the truck beforehand.
And yet the district judge, with regard to the Mini Cooper at least, doesn't even talk about that, right? He just says, although the tipster was incorrect about the owner or even the driver of the Mini Cooper, it matters little. In fact, it wasn't the tipster that was incorrect, it was the affidavit that was incorrect about what the tipster informed Detective Ross and kind of played some word games about whether or not Mr. Houston was actually driving the Mini Cooper that night.
And let me just lay one more thing on there. The Mini Cooper information is really the only information in here that is really attempting to corroborate what was told by the tipster. Because this is represented as the tipster said that, and yes, we saw the Mini Cooper, kind of suggesting Houston was driving it. So there you go, Mr. Whalen.
In 5 minutes.
Your Honors, I'm happy to address all those points to the extent I can. To the extent I miss any, please let me know. Judge Lee. All right, let's talk a little bit about paragraph P. To the extent that it was suggested that it was written to be a little too cute at half, Detective Ross was asked about this. He was asked about this during the hearing on page 128. And did you intend to mislead the magistrate judge or the issuing judge when you said this? He says no. He says, I didn't mean to imply that Mr. Houston is the one who's driving this car. I didn't mean to imply that he was the one that we saw get out of the car. He says, I should have written it differently. He acknowledges he should have written it differently. And admittedly, the district court doesn't go through each one of the alleged omissions and says, here's why I believe this particular explanation. Here's why I believe this particular explanation. I think the court talks about it more in kind of a global summary, saying that I believe, and this is page 6 of the court's order, the court finds no evidence that these omissions were made recklessly or intentionally, and the court says that the court finds Sergeant Ross's testimony credible. By finding that Sergeant Ross's testimony was credible, the court, I believe, is sending a signal to at least this court that it's finding his explanation that he just wrote it poorly, paragraph P. And he acknowledged as much. And it's possible that a different district court judge might have reached a different conclusion. It's possible that I read the record a little bit differently and that your honors might read the record a little bit differently, but we aren't the ones sitting observing Sergeant Ross testify. Sergeant Ross, there's one thing to say, yeah, I wrote it badly. There's another thing to show genuine remorse. And that's why the clear error standard of review matters in this case, because the district court's the one who's sitting there observing Sergeant Ross. To the extent that there's questions about corroborating and what else they corroborated of the tipsters' allegations, they sat there for 5 hours, 6 hours observing. They saw 30 people come and go on a cold, snowy February day. They believe that they corroborated the tipsters' information.
But some of those people coming and going were very legitimate.
That is certainly the argument. There are some people, there's a person in the back you can see on the poll camera who's fixing a car. There are his roommates, I think they're identified later on. It's also the tipster also tells the police officers that Mr. Houston delivers. So while roommate might be an innocuous explanation as to why they're there, the fact that the Mini Coupe that is affiliated with this address is coming and going multiple times throughout this particular observation period, and that the roommates might have been there. I mean, there are innocuous explanations. I don't think those have to be inferred per se on this record. I think hopefully I got through your honors questions on those issues. To the extent that I didn't, I'm certainly happy to address them. The fact is, the district court lists a bunch of bullet points on page 4 and 5 of its opinion that it believes are omissions and the singular misstatement. The courts recognize them. The court, Mr. Ross, Officer Ross, Officer Smith were both asked about them. Officer Smith says that I could see the entranceway to the apartment, but I couldn't see the right door. It's technically wrong that someone saw Gregory go into the left door. It's certainly a reasonable inference that he did. The court was able to observe their testimony, observe their explanations, and it did find that there were omissions. I mean, we can't fight that fact as we sit here on appeal. But the arguments that are being raised again, to the extent that they were raised to the district court, are the ones the district court considered. And it heard Sergeant Ross, it heard Officer Smith testify. It made a credibility determination, and that was not clearly erroneous on this record. I'm aware of a single case where this court has reversed a district court's credibility determination after a Franks hearing, and that's the Whitley case that we cited in our brief. That's a case where the district court judge finds the officer lied in one case and then turns to the co-defendant's case and says, I didn't even think he lied on this case because there's corroborative evidence. And this court looked through the record, and there was no corroborative evidence. So you rightly reached the conclusion, well, if you lied in this case, but you believe the corroborative evidence supports it, but there's no corroborative evidence, that's clear error. That is not this case in front of this court. To the extent the court has any further questions, there was a lot of discussion on good faith, but we'll rest on our briefs on that unless the court has any questions. Thank you, Your Honors.
Mr. Pennington.
Thank you, Your Honor. I would say that with respect to the misrepresentations, I would disagree that there was 30 people coming and going. During the relevant time, it was far less. The video footage certainly it just does not corroborate that testimony in any way. And it's not a 4.5, 5 hour period of surveillance. It's a roughly hour and a half period of surveillance. There's a protracted break, and there's about another hour and a half period there as well. So it's a very minimal amount of preliminary investigation here, and it doesn't support what's in the affidavit. There's not constant foot traffic coming and going. There's not cars coming and going. And with regards to the abuse of discretion, the district court doesn't grapple with the green Mini Cooper, as Judge Lee alluded to. It doesn't grapple with the blue Hyundai. That's simply not it's in the affidavit, but it is not observable in the video footage. That's the basis of the abuse of discretion here. The district court certainly heard testimony, but the abuse of discretion standard turns on whether there's a firm conviction of whether a mistake has been made, and this is exactly that case. We understand that the court's precedent here certainly favors not applying the suppression remedy when a warrant is sought. We certainly understand that. But if there's a case where remedy should be suppression here, this is it. This is exactly what the good faith exception was not designed to do. We specifically have here a violation, and what we have here is a case where you have suppression being the appropriate remedy. It's exactly what it's designed to do, and that's to deter police. I would say at the very least reckless conduct here. It's a sloppy warrant. It's put together in a way that it does not correlate at all with what was observed on the scene. This is not a case where the remedy should not be, where the remedy should not be the exclusionary rule. So for those reasons, Your Honor, we would ask that the district court reverse here and remand.
Judge Steve, can I ask one
Yeah, of
question?
course, of course.
Mr. Pennington, what is your response to the point the government makes that here Detective Ross spoke to a deputy prosecutor, that he consulted with a deputy prosecutor, showed the deputy prosecutor the affidavit, and so it's not him just acting rogue on its own. He actually consulted with someone outside the department before submitting the affidavit and the application.
Your Honor, I would say that that information can be prima facie evidence of a lack of bad faith or good faith. But the information that's shared and that's reviewed is only as good as the source of information. The district court placed dispositive weight on the conference, but the conference is only as good as the information that's shared. If we have up to 5 misrepresentations and those misrepresentations are not conveyed to the prosecutor, such as a green card not actually arriving, a blue card not being present, someone not exiting the door as stated, that the person who's actually being pulled over is Gregory Randall, a known drug dealer in and of himself. If that information is not communicated, then the conference with the prosecutor serves no utility. It doesn't help the showing of good or bad faith because the information proffered to the prosecutor is not accurate. So I don't think the court can rest here just solely on the act of communicating or conferring with the prosecutor. The information conveyed there needed to be accurate too. And if the court has anything further, we will rest.
No, thank you.
Thank you, Mr. Pennington. The court will take the case under advisement, and that concludes oral arguments for today.
Thank you.